one.
So why, when some completed, why did not you approach?
Because at that point of time, I was in the service. This aspect of the matter, one of the similar, identical, also decided by Justice Bhattacharya. Yeah, whether you can, at that point of time, as the all petitioners are working in schools and the Supreme Court matter was pending, it has not been decided. That's why I could not appear in the counseling process, in the last counseling process. The further counseling process has been fixed up on first. So, the court.
No, but I already come.
Yesterday, the notification was published.
Come on Tuesday,
Tuesday.
29th.
Grateful, extremely grateful.
But give notice.
Yes, certainly.
And affidavit of service.
Yes, certainly.
Motion top.
Extremely grateful.
But may I have your lordship can
Yes, yes.
is to mention, my lord, for inclusion in your lordship list, group 6 matter. I have
Group
given
6.
notice to the other side. Yeah.
Motion or
Motion.
hearing?
Motion.
How many?
Only one I have given notice to the other side.
Motion, August monthly list.
Monthly list, put in the daily list cannot be postponed.
Next,
Yeah.
monthly list.
May I be one
Your lordship.
matter, my matter, lordship. It's a group
Take
6.
the microphone.
It's a group 6 matter, lordship, under the to be included under the heading motion. The petitioner is a senior citizen, extremely urgent. He has
What
not.
is the urgency?
The urgency is that he has not received the interest on retirement benefits from 2011, and the matter has been interest. He has received the pension, but not interest has been not been given to him.
Against whom?
Against the state of West Bengal. Your
Which department?
Calcutta Tramways Corporation.
Calcutta Tramways.
Ah.
You appear? She appears. Have you solved?
Yes, lordship.
There are series of matters. You go contact her. She will give you the order. Then change those orders according to your facts and come back. Have you understood?
Yes, sir.
What do you have to do?
To contact her and then
You make him understand.
I will explain.
And you serve the petition on the have you served?
yes, lordship.
You have served.
Yes,
So file affidavit of service on that day. Right? Give her a copy also. Writ petition. It will appear. August 6.
Okay, I'm ready.
Motion service. Yes.
May I mention, lordship? My lord, this matter appeared on 23rd July, disposed of. My name is wrongly appearing. It should be Ratna Das. It came as Ranjana Das. It should be corrected, my lord.
देखिए कि to be mentioned tomorrow. Later, yes.
May I have your lordship leave to mention one urgent matter? It is pertaining to Group 2 education matter from the determination of Honorable Justice Shogata Bhattacharya. This matter, the petitioners are untainted candidates, teachers. They have challenged the second SLST 2025 recruitment process. The recruitment process is about to start and already started. So kindly
mention before. Kindly do it before his lordship.
Yes, some urgency. The 2 points already order was passed on similar matter, but some points we have to argue. Though that's
come after his lordship come back. Next.
I am appealing for the petition.
My lordship, I am for the respondent. Actually, my senior Debrina Chaturaj Deblina Chattaraj.
But it is something, if it is something urgent, then I cannot wait. What is the urgency?
Milord, urgency is Milord. I am member. In two nutshell, I'll tell you, Lordship. I'm member of the scheduled caste, Milord.
Huh?
I am member of the scheduled caste, Milord. I am a senior engineer in West Bengal Transport Corporation, Milord. Notification was Milord issued for the post of promotion of Milord chief engineer, Milord. Milord, there Milord 50-point roster was not applied, Milord. Earlier occasion, Milord 2015, Milord, similar notification, Milord, it was applied, Milord. Though it is a single cadre post, but my contention is, Milord, earlier occasion they allowed. Since there was no, I won't say though, there was no scheduled member of the scheduled caste working as a Milord senior
It is a
engineer. But
policy decision.
I-
Which shall be applied, which shall not be applied.
Milord, but Milord, I'll show your lordship the act itself, Milord. Though Milord, I am running on a sticky wicket on one aspect, Milord, that section 3F says that for employment in a single cadre, Milord, it is annexed, Milord. Milord, I have affirmed two supplementary affidavits where
Have
Milord.
you served
Yes, Milord.
supplementary?
Yes, Milord. Milord, supplementary affidavit, Milord, affirmed on Milord 23rd of June. There, Milord.
Two supplementary.
Yes, Milord.
Why?
I'll tell you, Lordship. First in the month of June, thereafter July, because Milord, that was the urgency, Milord. Interview date has been, Milord, fixed on 27th. 27th. So that's why I had to bring it on record, Milord. Milord, 29th. So I'm so
You have
sorry.
received these affidavits?
My lordship, I am not aware of it. I have to check it.
All right. Since
Milord,
there is urgency, let me hear it.
Milord, 23rd of June 2025, the affidavit, the supplementary affirmed, Milord. Let kindly
Show me that
First,
first,
Milord.
show me section 3.
Section 3. Milord, before that, may I show the 2015 notification?
I admit it is
Very well,
there.
sir. Milord, that is, Milord, in supplementary affidavit
Show
affirmed
me
on
section 3.
Section
Come to the
3 is
legal point
page, Milord, 5. Milord, kindly comes to page 5
of the
of the supplementary affidavit affirmed on 23rd of June 2025, Milord. Mhm. দুটোই হ্যাঁ ঠিক আছে Let page 5, Your Lordship. May I read?
wait.
My contention is, Milord.
Wait. Yes.
My lord, section 3, Milord, on this particular issue, Milord.
Last F.
Yes, F. any employment in single post cadre, millet. Millet thereafter, millet kindly comes to, if millet it pertains to my contention, it pertains to only millet appointments, fresh appointments, not promotions. If it also contains relates about promotion, I am out, millet. That
You are
section
already an employee.
I am already an employee, millet, working as millet, senior engineer, and vying for the post of millet, chief engineer.
So you say that it is a new appointment.
Yes, no, it is a promotion. For promotion, section 3, clause F does not apply.
That's
My
right.
contention is that, millet. Millet kindly comes to millet, section 5. Since section 5 is there, millet, that is the reason, millet, I could muster courage to come before your lordship. Let kindly finds reservation for members of the scheduled castes and the scheduled tribes in vacancies to be filled up by promotion in any establishment shall be regulated in the following manner. There shall be reservation at 22% for the members of the scheduled caste and 6% for the members of scheduled tribes in the manner set out in schedule 2. Millet, then the schedule 2 is, millet, page 16, millet. For once, millet, kindly comes to, millet, page 16. Well, page 16 says there is the schedule 2, millet. So it says the reservation for the members of the scheduled castes and the scheduled tribes in vacancies to be filled up by promotion in an establishment shall be given effect to in the following manner, namely, a roster of 50 vacancies will be necessary to give effect to the reservation for the members of the scheduled castes and scheduled tribes in vacancies to be filled up. The roster given below shall be adopted by the purpose for each establishment. Millet, first vacancy, scheduled caste, millet. So, millet, section 5 comes to my rescue. Millet, then coming back to, millet, page 6, section 5 itself, millet.
Have you made any representation?
Yes, millet.
Where?
Millet, in my writ petition, millet, page 21.
Have they disposed of?
No. Though I have applied, I could not take chance. I have applied also, millet. But in the application also, I have said in the last application in millet, page 20.
Page 21.
In my, yes, millet, 21 is the writ petition, is the millet representation, millet.
When the promotion list will be published?
Millet, interview is to be held on 29th, millet, of July at 12:30, millet. Let them give me a hearing. I will, if your lordship.
Because this needs to be otherwise gone into by way of affidavit, which will serve no purpose.
Let them consider my representation.
My lordship, can I come back after 1 week?
But then what will happen to the interview? Then you allow him to participate in the interview without prejudice?
They have allowed me to participate in the interview, but my contention is, millet, if 50-point roster is, millet, applied.
Oh, then there is no urgency. I'm simply directing this representation to consider.
Yes, millet.
I'll record that you have been allowed to participate in the interview.
Yes.
Right?
I have been allowed already, millet, but my contention, since 50-point, if 50-point roster is, millet, applied, millet, then I am the sole candidate.
Without participation, prejudice to your rights and contention, you shall participate.
Yes.
And the result in the interview shall abide by the result of the reasoned order.
Mile.
Ashu. On the prayer of first Mr.
Srinjoy Sengupta.
Srinjoy Sengupta, learned advocate, appears for the petitioner. MS?
Olomi Chattopadhyay.
Poulomi Chattopadhyay, learned advocate, appears for respondent numbers
225.
2025. Who else is appearing? Anybody else is there?
No, no.
No.
Only West Bengal Transport Corporation is the party, millet.
So you are one also,
Yes.
has
Yes,
to
yes.
be.
225.
No, not 225, not 2
One
managing director.
or respondents.
Yes, millet.
1.
Respondents. Full stop. The petitioner at present is working as
Senior engineer, millet.
senior engineer with the respondent number 1.
My lord.
The petitioner is an aspirant for the promotional selection process. Promotional selection process to the post of
Chief engineer.
chief engineer. The interview is scheduled on
29th of July.
July 29, 2025. Bold. Interview কতটা bold? Date bold. Petitioner as a scheduled caste
My lord.
candidate.
My lord.
Petitioner as a scheduled caste candidate. না ঠিক আছে যে কাটুন লিখুন petitioner has been
Goes without saying.
selected for the interview
My lord.
and he shall appear in the interview on the day it is scheduled. Paragraph. The petitioner is a single is the single oh, there is no reserved post for this.
No, that is why, millet.
All right. The petitioner is a scheduled caste individual.
My lord.
Full stop. He claims reservation
My lord. Under 50-point roster, millet.
under 50-point roster under the provisions of the এটা পুরো লিখে দিন আইনটা The petitioner has ওহো তার আগে তো ওইটা লিখতে হবে দাঁড়ান মাথায় চলে যান on the prayer of appearance on the prayer of the learned counsel for the petitioner leave is granted to the petitioner to file 2 supplementary affidavits.
Grateful.
One is affirmed on
June 23, 2025.
June 23, 2025.
Another July
The
18.
other one on July 18,
18.
2025. Poster. Leave is কি বললাম on the prayer of sir. Fine, sir. The supplementary affidavits are taken on record. Full stop. Copies have already been served. As this court has been informed
My lord.
on by the learned advocate for the petitioner. এবার কি বললো? The petitioner has submitted its representation dated
Submission, reservation,
representation.
representation on Millard.
Page.
Page 21,
From
April 11, 2025.
April 11, 2025. Annexure P4 at page 21 to the writ petition. But the same has not yet been disposed of. Paragraph. In view of the above, subject to the conditions imposed hereinafter, the necessary directions are passed. Paragraph. The respondent number 3, upon issuing a prior hearing notice of at least 3 days to the petitioner, 3 clear days, 3 working days to the petitioner, and after granting him an opportunity of hearing, shall dispose of the said representation dated April 11, 2025 at page 21 to the writ petition by passing a reasoned order in accordance with law. Full stop. Paragraph. The entire exercise shall be carried out and completed by the respondent number 3 positively within a period of 3 weeks from the date of communication of this order. And the reasoned order shall be communicated to the petitioner within a further period of 1 week from the date of the said reasoned order from the date of the said reasoned order to be passed. Paragraph. It is made clear that this court has not gone into the merits of the rival claims of the parties. Full stop. All points are kept open for the decision to be taken by the respondent number 3. Paragraph. The petitioner shall participate in the interview scheduled on
29th, July 29th.
July 29, 2025 without prejudice to his rights and contention
Yes.
and his assessment in the interview shall not be published till the reasoned order is passed. And the same shall be kept into the sealed cover before with the appropriate authority. Full stop. Finally, the assessment and performance of the petitioner in the interview process shall abide by the result of the reasoned order. Paragraph. It is made clear that while assessing the petitioner in the interview process, the same shall be an independent assessment, and the interviewing authority shall not be influenced by any observation made by this court or made by this court, comma, if any, full stop. In the event the petitioner becomes successful in the interview process, his fate in the selection process, his fate in the promotional selection process shall be considered in accordance with law. আবার পড়ুন তো একটু না ওই আপনি ওইটা পড়ুন 6 week এই 3 weeks 1 week যা হলো তারপরে প্যারাগ্রাফটা হলো তারপরেরটা থেকে
and his assessment shall not be published. This order is passed, and the same shall be kept into the same
to na ine paragraph finally.
Shall abide by the result of the order. Stop that. It is made clear that while assessing the petitioner in the process, the same shall be an independent assessment, and the interviewing shall not be influenced by any observation made by this court, comma. When the petitioner becomes successful in the process, his fate in the selection process shall be considered in accordance with law.
I'm grateful. Full stop. Paragraph. Since affidavits are not called for, the allegations made in this writ petition are deemed not to have been admitted by the respondents. এটা ফুলস্কেপে ছাপবেন ওটা কি যেন কি বলে M10 ছাপবেন কিন্তু জানবেন ছাপবেন দেবেন এটা এটা কোন ডেট আমি ডিসাইড করব
May I suggest one thing?
কি বললাম
Your Lordship had directed Millet, his assessment will not be published. Other two candidates are also there. Millet, nobody's assessment should be
No.
published. Millet, yes, please.
why
Millet,
3 weeks if you stood first, if
Yes, sir.
ultimately you become first,
yes, Millet.
your fate will abide after the reasoned decision.
Very well.
Why? And they are not before me. Why
No,
should
no,
I
no,
hold
no,
them?
no. I.
বললাম, it is further clarified that this order shall be restricted only for this writ petitioner
Fine.
only.
Smile.
I'm
I'm
grateful,
grateful.
ma'am.
Only for this writ petitioner.
I'm grateful.
I'm grateful, my lordship.
Therefore, with the above observations and directions, this writ petition bold WPA 9557 of 2025 stands disposed of, comma, without any order as to costs.
Grateful.
It is supplementary and review service.
Why again supplementary?
Because the date I mentioned before your lordships, and the interview is scheduled to be held on 28th. That is it is mentioned. The matter was moved before the vacation bench. As the interview was not scheduled, it was submitted by the school authority. That's why it was adjourned. And whether there is no such urgency, but now
Mr. Ekramul Bari, learned advocate, appears for the petitioner. Mr. Dipanjan Dotto, learned senior government advocate, senior government advocate, senior advocate, senior government advocate, appears for respondent numbers
1, 2, and 3.
1, 2, 2, 3.
For the
Mr.
school authority, Sudhakar Thakur.
Sudhakar
Thakur.
Thakur, learned advocate, appears for respondent number
4 and
5, oblique school authority, আর উপরেরটা oblique state, Dipanjan. Yes.
Madam, the 6th October 2007, this is a schools, my lord, the Arjokonna Mahavidyalaya schools. It is governed by the special rules. Service Commission Act has got no applications. It is for the schools they can recruit. So, my lord, in October 2007, I was appointed against a vacant post. And till date, I have been serving that said institutions. Now, my lord,
As
assistant teacher in science group. Now, my lord, the regular selection process was not carried out. And now, my lord, they have fixed up the date, my lord, to conducting after publishing the advertisement. And this interview is scheduled to be held on 28th onwards. Then, my lord, I became H-bar in the meantime. From 2007, I was in 30 when I was joined the schools against the vacant post. Now, my lord, I made an application before the school authority that kindly permit me to appear in the relaxations. My lord, page 18 is the prayer made before the school authority. Page
19.
19. 19. Now the school authority, my lord, they rejected my prayer. Page 20. This is the subject matter of the challenge. Page 19 and 20, your lordships kindly text up.
how old are you now?
48 years.
Now I am, my lord, at that point of 30 years.
No, today.
Today, 48 years. Today, 48 years.
So you received the job at the age of 18?
30.
No, 30.
30. Yes, show me the reason.
Now, my lord, this page 20. This is the communication by the school authority.
Yes.
Lordship, got it?
আচ্ছা,
Page
এক মিনিট
20.
এখানে আসুন তো। Upon urgency being pleaded, first paragraph, upon urgency being pleaded on behalf of the petitioner, since the interview is fixed on
28th.
28 July 28, 2025, and since the regular determination has been assigned before this court, comma, the instant writ petition has been taken up for consideration upon being mentioned on behalf of the petitioner by including in the day's cause list.
Now, my lord,
Yes.
the question is whether the relaxation is permissible in the eye of law or not. So, my lord, I have been working against the সাত মানে কত বছর হচ্ছে না না 7 মানে 2007 অ্যাপয়েন্টমেন্ট পেয়েছিলাম 18 বছর হ্যাঁ
18 বছর থেকে last 18 years.
Show me the notification.
the notification
Page
of
17.
the page 17
17.
17
Your subject is there.
yes
That is
science
Sanskrit, show me.
no no
Hindi,
application
physics, is the physics, chemistry, biology.
teaching of life science
She is teacher.
science. Your lordships kindly see the Roman 2, clause 2, Roman 2, B.Ed, DLAD or equivalent from NCT approved institution, mathematics, science, Hindi and English.
So Sanskrit is not there.
Not Sanskrit. Science.
Oh, you are science.
Science.
Sanskrit is not.
Science.
Yes.
Now, my lord, although my lord, the twofold prayer I have made alternatively for appearance in the interview, long continuous service separate for regulations. Now, my lord, initially the concept of the regularization now has been changed. Initially, Uma Devi was striking in the field that the appointment, if is a illegal, irregular, has been defined. Now, my lord, the Supreme Court has changed the view. The Uma Devi is not the shield in considering the long tenure of the service if they have got the requisite qualifications and the adequate whatever training.
Show me the judgment.
But I am not placing that judgment today. I will be restricting myself. Prayer B. Prayer B is for to appear in the interview after condoning the relaxation of the age. Now, my lord, whether
Show me I have power
yes,
to alter the
yes,
condition of
right,
appointment.
Right. It is just with that. The larger bench of this court, my lord, considered the issue. This is reported in 2013, volume 1, CHN, page 9. The relevant portions. Para 26 onwards.
Page কত? 90. 19.
Yes, which portion?
Para 26. In view of the above discussion, we conclude as follows.
Yes, sir.
Para 27. If the appointment is made without
No,
undertaking.
no, as follows, read on.
Para page 27.
No,
Uh,
no, 26 complete.
In view of in view of the above discussion, we conclude as follows. No ad hoc or temporary appointee can be absorbed, nor be regularized in any post in the government or government aided establishment, divorce of the recruitment rules or service of the rule ordinarily. Second, 27. If the appointment is made without undertaking a selection procedure under the rule on ad hoc or temporary basis, engaging the candidates having requisite qualifications, namely the age and education at the time of appointment against the substantive post, the candidate in those cases shall be allowed to compete and participate in the selection process along with the other eligible candidates at the time of regular recruitment process, condoning the age as they have acquired a right to be considered. Of course, their service must be continuous and without any break in the vacancy of the substantive post at the time when the regularization is demanded and selection process undertaken. But in case where the appointee are not qualified at all and they have been engaged on rendering service as on ad hoc basis, temporary basis measure, their case cannot be considered under any circumstance either against a substantive post or the post yet to be created. The question of non-qualified candidate does not arise. Well, I have got the requisite qualifications and the training qualifications, whatever advertisement prescribes, that criteria I have fulfilled. This is.
If the appointment is made without undertaking selection procedure.
Under the rule on ad hoc or temporary basis, engaging the candidates.
Here a selection process has been undertaken.
No. If the appointment is made, if the initial stage, if the appointment is made without undertaking selection process under the rule on ad hoc or temporary basis, engaging the candidates having requisite qualifications, namely age and education at the time of appointment against a substantive post, candidates in those cases shall be allowed to compete or participate in the selection process along with other eligible candidates at the time of regular recruitment process. Regular money is going to be held on 28. Along with the recruitment process, condoning the age as they have acquired the right to be considered. And the second portion, para 28 says, if they do not have the required qualification, that the question is different, totally different. Initial appointment 2007. আপনাদের স্ট্যাবলারটা দেন তো।
Yes, let me hear them.
Yes.
We have no objection. The lordship permit her to sit in the interview because we have no authority to relax the age matter. That's why we have rejected her prayer for relaxation of age matter. Otherwise, she is eligible to be.
And as far as state is concerned, state is concerned, the post might be sanctioned post. But since it wasn't temporary arrangement between the school and the individual, this was not approved by the state. So unless it comes to us, we have nothing to comment on, rather, because it was absolutely an internal arrangement between the individual and the school as of now. Unless it comes to the DI for approval, then
Of the entire.
yes, then we have the jurisdiction to even go into this. But as of now, we have nothing to comment on.
So after the interview process and everything is over, they will prepare the panel.
Yes.
They shall send it before the DI.
Yes.
Then DI shall scrutiny everything
Yes.
and shall approve or disapprove.
Or disapprove. Then the question of this age bar can come in.
Even if he is
Selected.
participates,
And
then it will be decided by
yes.
No, participation cannot be made
no.
in violation of the notifications. Participation, it has been made out, the categorically mentioned the age limit will be such and such.
Absolutely, 40
So,
years.
Yes, to show after 40 years, nobody can appear. But Mala, my case is that we are not coming. I have rendered my services against the vacant certain post and Mala last 18 years. Now there is no scopes. There is no scopes for further any appointment. I am only taking chance if I can prove my ability. If my lord, I am a successful
So
candidate.
at the best, can this be done? Mr. Dotto and you. If she is allowed to participate in the interview, on the basis of the performance, you will prepare the panel, her assessment will be made. Then the entire panel will be sent before the DI as per law, and the DI will be free to decide on the panel.
Yes.
Including the case of the petitioner.
Yes.
My lord, unless the age is relaxed, the DI cannot. My participation,
the moment I allow her to participate in the interview,
after condoning the age.
No, I will not condone.
Because that is the exactly.
I will simply allow her to participate.
Yes, that means ultimately allowing.
Final decision will be the decision of the DI.
No, that decision came. So far the age bar is concerned, DI cannot take decision. It has been decided by our larger bench. So far other eligibility, your lordship is absolutely correct. So far their qualifications, so far the performance.
If ultimately DI finds
yes
that
so far
it goes contrary to page 17 notification.
No, that cannot. That is my case here. What is my case? My case is, my lord, the challenging the decision of the school authority whereby and whereunder the prayer for relaxation was rejected.
Right.
So your lordship is considering today whether the school authority can relax, whether the decision of the school authority or outright rejections in violation of the Govinda Mandal is tenable in law or not. If your lordship hold, no, your lordship, I have the right to be considered along with the others. So for other aspects is concerns, no problem. So for my lord, the performance, experience, education qualifications. If I do not have the education, the question of different issue. So for condonation of the SDI has no power. DI has no power. Only the court can do that. And in view of the matter, this exactly paragraph 24, this point was taken. Your lordship.
Any further development after this judgment?
No, this is still the judgment is the good law. Paragraph 20, it appears the division bench held that even relaxation, the age in case of recruitment is not permissible under any circumstances unless there is express power to that effect. But this argument was advanced. No, the court cannot do that.
Very well.
Now your lordship.
As an interim order, I am allowing you to participate.
Very well.
Then the regular bench will decide.
No problem. let them file an affidavit in the meantime if they choose.
That
That liberty, your lordships, let it be decided. That liberty, your lordships can give it. In the meantime, we shall exchange our affidavits.
Then only one thing. If I suppose Mr. Bari's client is selected, then the panel will remain in a state of abeyance, because ultimately it will either it will remain in a state of abeyance or has to depend upon the result of this writ petition.
I will grant you liberty to mention before the other bench,
Fine.
regular bench.
Fine.
First.
Or if I do not pray for regularization, your lordships can simply dispose of the matter, permitting to
No,
appeal.
I have to hear them out whole on affidavit. After whether, because I tell you first thing, I can't find from this judgment what was the tenure that was relaxed. Had it been 6 months, 8 months, 1 year, fair enough. In your case, it is 8 years. In your case, it was 8.
Principle.
No, principle will depend on fact, Mr. Bari. Principle will depend on facts. I tell you, I give you a simple example, sir. You are a veteran.
We are discussing the law, no problem.
You are a veteran member of the bar. Suppose a condonation of delay. I'm simply giving a simple explanation. There is a delay of, let's say, 15 days. An explanation is not sufficient. Ignore. At best, 50 rupees cost and ignore. If the delay is of 300 days and the explanation is not sufficient, then of course the complexion changes.
That is, here, my lord, what was the case? Case was the regularization, prayer for regularization.
No, sir. I am saying the legal principle for condonation of delay is the same. But that is why I read this judgment. I tried to find out whether it was for 8 months, 9 months, 1 year, 1.5 years. But your case is 8 years. Your case is 8 years. So apparently, I have a distinguishing feature.
Only the paragraph 6.
It's not there.
No,
Quantum not there.
Your lordships can take that.
Yes. Why not?
Para 6. Concluding portions.
Attainment of the age of 37
It
years.
has now become settled law that ad hoc and temporary appointee in the said place should be allowed to participate in the selection process when to be taken on regular basis, regularizing the age bar. Accordingly, submits that the alternative question be answered if the affirmative relaxation of the age bar in case incumbent who joined the college long before attain of age of 37 years. So, show my lord, I joined the college because at the time of
10 years before 40 years.
Right.
I admit.
Right.
I admit, sir. But the thing is, ultimately, if 8 years, then tomorrow another will come for 13 years.
My lord, if the initial appointment within the age limit, if I come after 37 years, it is not permissible. If within
all right,
only one thing, this is a minority institution.
Yes,
special
status. It is
So,
for the school.
only this has to be noted somewhere.
No, I have said so in paragraph 2.
Yes.
No, he started his
Yes,
submission. with
special
that.
rules.
Minority. Special.
Very well. The subject school in question, bold করে দিন, দীপাঞ্জন বলেছে, it's a minority institution. Paragraph. Pursuant to and in terms of the selection notification dated December 1, 2024, Annexure P2 at page 17 to the writ petition, the petitioner as an aspirant applied to participate in the selection process. The notification stipulates the qualifying age limit is 40 years. And the petitioner belongs to general category. 40 years for the general category, and the petitioner belongs to general category. The petitioner now is about 48 years. The petitioner joined in the service as an assistant teacher of this at the subject school on, sir,
2007.
6 October 2007.
October 6, 2007.
2007.
October 6, 2007. As pleaded in paragraph 3 to the writ petition.
6. With effect
3 of
from
the
6
writ petition.
October 2007.
Copy.
The petitioner claims relaxation of age limit so that the petitioner can be permitted to participate in the selection process for
Science group. Science group.
Science group.
For science group. For regularization. For participation.
The petition claims relaxation of age limit that the petitioner can be permitted to participate in the
In the selection process for regularization.
For regular recruitment. For regular appointment.
For regular appointment in the science group. Paragraph. Mr. Ekramul Bari, Learned Counsel, appearing for the petitioner, submits that the petitioner, when joined in service as a temporary teacher in the year 2007, he was around 30 years age, 30 years old. Full stop. Had the selection process for
appointment of a science group teacher.
Permanent teacher.
Permanent.
Had the selection process for permanent teacher being carried out for about last 18 years, she would have been easily within the age limit prescribed under the advertisement. Petitioner has already rendered service as an assistant teacher for about 18 years.
Continuously, without any interruption.
18 years continuously and without any with an unblemished career record. With an unblemished career record. The teaching experience of the petitioner is profound. He submits that if the age bar is relaxed, then the petitioner can participate for the selection process. First. In support, Mr. Bari has relied upon a decision of the larger bench of this court in the inter alia in the matter of Govinda Chandra Mondal versus Principal Ravindo Mahavidyalaya, আমি দিয়ে দিচ্ছি আপনাকে, reported at এইটা আর এইটা করে দেন। রিপোর্টেড একটা ইকুইভ্যালেন্ট হয়ে যাবে, মাঝখানে চিহ্ন দুটো সাইটেশনের মাঝে।
Adjournment করে। অনলাইনও আছে।
Mr.
Sudhakar Thakur.
Sudhakar Thakur, learned advocate, appearing for the school submits. What is the submission?
So we have no objection, my lord, because we have no authority to relax the age.
That the school authority has no objection on the prayer of the petitioner, as the school authority has no jurisdiction to relax the age bar. Poster. Referring to the rejection of the prayer of the request, we are referring to the rejection of the request of the petitioner dated May 14, 2025, annexure P5 at page 20 to the writ petition, comma, he submits that the school has already informed the reason to the petitioner and did not permit the petitioner to participate in this election process. Paragraph. Mr. Dipanjan Dotto, learned counsel, submits that at this stage, the state has got nothing to do. Poster.
Only one thing, this was never before us, before the DI for approval or anything.
সেটাই তো বললো।
Listen to me, has got nothing to do, and unless the records and documents are placed before the jurisdictional district inspector of school for approval of the panel, comma, the state authority does not acquire any jurisdiction over the issue. Full stop.
This was an absolute interim arrangement.
This is an arrangement between the
Private
school and the candidate. Paragraph. After rival contentions of the parties, and upon perusal of the materials on record, and upon reading the said decision of the larger bench in the matter of Govindo Chandra Mondol, as an interim measure, the petitioner is allowed and permitted to participate in the selection process pursuant to the said advertisement being annexure P2 at page 17 to the writ petition, full stop. The petitioner shall participate in the interview scheduled on
28th of July 2025.
July 28, 2025, without prejudice to the rights and contentions of the parties to this writ petition. Full stop. Paragraph. However, paragraph no songe. However, this order shall not create any right or equity in favor of the petitioner until the writ petition is finally decided. Full stop. The school authority shall also be at liberty to place the panel before the jurisdictional district inspector of school after the selection process will be over. The DI shall scrutinize everything, but shall not pass any final order, but shall not take any final decision on the panel till this writ petition is decided. Full stop. Paragraph. The respondents shall file its affidavit in opposition on or before. Give me.
3 weeks.
Tell me.
3 weeks time, my lord.
3 weeks, 1 week, you'll also skip it after 4 weeks.
4 weeks.
4 weeks, 2 weeks.
No, 3-1 করুন। 3-1. 4 weeks every year.
August 25, 2025. Reply, if any, thereto by September 2, 2025. Full stop. Paragraph. The parties shall be at liberty to mention the writ petition for further consideration before the appropriate bench, subject to its convenience, before the regular bench, subject to its convenience and upon notice to each other.
Before the appropriate bench is a hearing matter,
Regular matter.
regular and appropriate.
Regular bench. The appropriate is also regular. Unless you show inappropriate.
Must-
Lordship, I am for the alleged contempt, Lordship.
He is compliant.
Yes, Lordship. This is
Have
my
you shown
affidavit.
to him?
Yes, Lordship.
Compliant.
You have taken a decision on negating the claim of the petitioner.
Lordship,
Now,
kindly
that
kindly
is a
come in the
different
reason order, page 4, Lordship.
That is a different issue. Ashu. Mr. Shamimul Bari, learned advocate, appears for the petitioner. Full stop. Paragraph. MS
Rupsha Chakraborty.
Rupsha Chakraborty, learned advocate, appears for the alleged contempt NAS.
Yes, Lordship.
Full stop. Paragraph. Today, a compliance report in the form of affidavit affirmed on July 22, 2025 has been filed and the same is taken on record. Full stop. The reasoned order is dated July 14, 2025,
Yes, Lordship.
appended thereto. Full stop. Paragraph. In view of the above, nothing further survives in this contempt proceeding, and this court is satisfied that the direction of this court dated June 6, 2024 stands complied with. Full stop. Paragraph. Accordingly, they came pursuant to the rule. They came.
Yes, Lordship. Kindly see the report, Lord, reason order.
And
Lordship.
you are saying, why should I? Full stop.
Grateful, Lordship.
Accordingly,
Rule was only against the contempt number 1.
whatever. Accordingly, WP bold WPCRC 155 of 2024 stands dropped and closed. Dropped, bold, closed, bold, enter normal. Dropped and closed paragraph. Rule bold, issued normal, stands normal, discharged bold. Rule, comma, issued, comma, stands discharged. Paragraph. Accordingly, WPCRC 155 ওইগুলো bold হবে of 2024 stands disposed of.
petitioner shall be at liberty to challenge the same if.
Why liberty? It's always with you. If you are aggrieved 100 times, more the merrier.
Applies.
Item number 4, my lord, I beg to upon the alleged contempt now, my lord. Order has been complied with, my
For the
lord.
petitioner,
Order complied.
Order complied, my lord. So for my instruction is concerned.
received anything.
So you come back after
Lord.
considering this. Dekhi din. Today, Mr. অমৃতল না এইভাবে লিখুন MS
চম্পা পাল
Champa Pal, learned advocate, appears for the petitioner paragraph. Mr. Amritolal Chattopadhyay, learned counsel, appears for
Alleged contempt.
alleged contemner. Paragraph. Today, a compliance report by way of a forwarding letter dated with a forwarding letter dated July 9, 2025, issued by the assistant engineer, PWD. File কি বললাম? Is filed in court. The same is taken on record. Full stop. Copy has been served upon the learned advocate for the petitioner today in court. Full stop. She shall take instruction and revert back to this court on the next day.
Your Lordship, kindly give liberty to file exception if required.
Full stop. Petitioner shall also be at liberty to file an exception in the form of affidavit, if necessary, in the meantime.
Grateful.
Grateful, my lord.
The matter the proceeding shall appear under the heading contempt application on August 8,
Grateful, my lord.
2025. আজকে কত? না, তাহলে August 8 করবেন না। August 22.
Grateful.
2025.
And I am for the petitioner. So
First time.
First time. My lord's order has been carried out to the appeal. Appeal court affirmed the order. My lord, thereafter, my lord, 2 directions was given. My lord, 2 directions.
What is the order? The কাগজ দেখি।
Page 30.
13.
30. Now it is reported judgment. Both the order is reported.
What was the issue?
My lord, issue is paying the compensation. 5 lakhs each. My lord, page 30.
Order upheld by the appellate court. Still not.
My lord, partly complied. My lord, the person who is responsible for the mischief, that person is deposited money to the Registrar General. But the authority, my lord, present PPSC has not deposited that amount till date. My lord, kindly see, my lord, page 30. My lord, now it is reported.
All right.
The person who, my lord, is given the direction to withdraw the amount if it is been deposited from the Registrar General. But as it is partly deposited, my lord can give me liberty to.
Liquid. This contempt proceeding arises from the order, judgment and order dated
February 6, 2024.
February 6, 2024, after being upheld, after not being interfered with by the Honorable Division Bench by its judgment dated
November 14, 2024.
Paragraph. Mr. Gaurav Das, learned counsel appearing for the petitioner, submits that the direction of this court stands partly complied with, but a substantive part has not been complied with. but the substantive part has been willfully violated till now. Paragraph. Today is the first day. Paragraph. Petitioner shall serve contempt application upon the alleged contemners.
Only one.
Only one. Alleged contemner. Then this contemner has not been complied with.
No, my lord, there is a direction upon your lordship, both at the council to deposit that amount and the then chairman. The then chairman has deposited, but
that's right. So no contempt against the then chairman.
I have not implemented party. Present chairman is a party.
ও না শুরু চলে যান পাটলি লেখার দরকারই নেই তো এর এগেনস্টে কমপ্লাই হয়নি কি বললাম না কেটে দিন that the directions of this court still is being willfully violated at the instance of the alleged contemner. Proper today is the first day. তারপর আপনার কাছে অনেক আছে করে দিন এটা রিটার্নেবল করুন বলে দিচ্ছি কবে এই 22-এর পরে 22 অনেক হয়ে গেছে 29 ঠিক আছে 29 ম্যাডাম 29 অগস্ট 22 অনেক হয়ে গেছে 22 অনেক আছে কি আছে আপনার আছে কি 29-এ দিয়ে দিন 29 অগস্টে তো ভালো মনে করেছেন সব কটাকে জেলে পুরে দিয়ে চলে যাও আবার ফিরে এসে তখন দেখবো August 22.
May I, in the meantime, withdraw the amount?
Wait. Pendency of this contempt proceeding. আচ্ছা এবার লিখুন এইভাবে লিখুন however pendency of this contempt proceeding shall not preclude the alleged contemner to comply with the direction of this court forthwith and to file a compliance report on the returnable day. Paragraph. It is also made clear that in the event দরকার কিছু আলাদা তারপরেতে অ্যাপিয়ার করবে ওই তারিখে ওইটাকে পরেরটাই করবে
both your lordship's order and the order of the division bench is being reported.
Thank you. Where? Give the citation.
But your lordship's judgment page 30 is reported to 2024 Supreme Calcutta.
Yes.
Page 29.
29. The DB?
And division bench is 2024 Supreme Online.
Yes.
Calcutta, Cal 4677.
Oh, so Supreme Calcutta, that's a bound volume. Physical format.
But I shall.
No. Because Supreme Online means it's online.
Online.
And what about Supreme Calcutta 29?
That is binding.
That's a bound volume. Provide me a Xerox. Bound volume. Xerox of that judgment.
Lordship, item 6 and 7.
Yes, next.
Lordship, item 6 and 7. May I be permitted to appear online, Your
The
Lordship?
petitioner is applying online.
Lordship, I'm online here. May I be permitted to appear online only for this day, Your Lordship?
Petitioner is appearing online, Lordship.
She's not audible.
Lordship, am I audible, Lordship?
You are not audible, madam. You are not audible. Compliance made.
Yes, madam.
Report submitted.
Yes, Lordship.
What is this?
Lordship,
Written
exception to the report.
Written objection made by the petitioner.
Lordship,
You are not audible.
Lordship, the exception is submitted by
Lordship been praying for not today.
Mr. MS?
Anubrata Datta.
অনুব্রত দত্ত। অনুব্রত দত্ত।
অনুব্রত দত্ত?
Yes, Your Lordship. Yes.
Some lady is appearing.
Yes, Your Lordship. My name is Anubrata. Yes.
অনুব্রতাই হবে। MS অনুব্রতা দত্ত, learned advocate through virtual mode, appears for the petitioner, applicant, appear for the petitioners. Mr. Chundi Charan De, learned additional government pleader, appears for the alleged contender. Full stop. The report has been filed, issued under the seal and signature. A report dated June 25, 2025. Issued under the seal and signature of the alleged contender, filed today in court, showing compliance of the direction of this court dated
15/7/2024.
July 15, 2024. It's taken on record, full stop. You have been served. You have given a copy here and now.
My lord, affidavit in reply filed.
To this,
that is mine. And to which data file করলে, he filed that, my lord.
Just now I have.
all right.
On the
Full stop. Full stop. So you are filing it today? No, it was filed previously.
My lord,
এই রিপোর্টটা আপনি আজকে দিচ্ছেন?
মানে এটা আমি আজকে বোধহয় আগের দিন দিয়েছি কিনা জানি না।
ঠিক আছে, আগের দিন আজকে ফাইল করলেন।
I have given.
ঠিক আছে। Full stop. Learned advocate MS.
Pratav Datta.
Your name?
Shilpi Pal.
Shilpi Pal.
That's why I'm not in.
Appearing for the petitioners. Physically in court, has filed a written objection to the report in the form of affidavit, the same is taken on record. Full stop. Paragraph due to technical glitch. Due to some technical issue, the learned counsel for the petitioner appearing through virtual mode is not audible.
I apologize, Your Lordship.
The hearing stands adjourned. The matter shall appear under the heading Contempt application on September 19, 2025.
Grateful, Your Lordship. Grateful, Your Lordship. Grateful.
ঠিক আছে, 19 হলে হবে তো?
Grateful.
Now, my lord, your lord.
Appearing for the petitioner on the last occasion, Lordship had directed. I mean, service to the On the last occasion, Lordship had directed to add the assistant engineer as a party in the contempt application. This is my affidavit of service.
My lord, I filed the, on behalf of the assistant engineer, I filed the, my lord, compliance report of that one. As because, my lord, there is no any LA.
Take microphone.
As because, my lord, there is no any LA and LR map was applied by the respective authority, my lord. It is not possible for the BLRO to complete the, my lord, the demarcation. But demarcation was made and the distance of the path, from the path, distance of the path and the encroachment, as my learned friend, my lord, stated that that is the encroachment. But we could not confirm that those are the encroachment of the PWD road or not. For that reason, my lord, it is not possible for the.
So what to do?
My lord, your lordship can, whatever your lordship can, as because, my lord, there is no any LA or LR map, it is not, LR map was not finalized. So, my lord, it is not given to the BLRO. BLRO said that is the position. And, my lord, ask the assistant engineer, give us your acquisition. You have, if you have any acquisition, must give the acquisition. That was not supplied by the, for that is, my lord, on the previous occasion, I requested your, my lord, to ask the assistant engineer to come and say what is the. My lord, assistant engineer said, I have no any. For that reason, he wrote a letter to the additional district magistrate, that is LA, to give me a copy. That copy was not given to them, my lord. So it is not possible whether those land were in the acquisition land or not. Whether that land was encroached by the path or not, my lord. That is the in that report, my lord, I have done so, my lord.
Rashi, if I may submit, we had approached the office of the subdivisional magistrate Canning, and what we have been informed by the magistrate's officer, your lordship, is that the assistant engineer has already submitted a report before the magistrate, which is not yet on record, and they have found encroachments, my lord.
Before
the assistant engineer has forwarded some report to the subdivisional magistrate, the SDO, and we had visited the SDO's
subdivisional officer.
And we had visited the office of the SDO, and the concerned official told me that they have given some report.
My lord, that should not be, that is, that position, my lord. My learned friend said, must
that
say.
Is still not on record.
Must say through the affidavit.
No, something, what he is saying that we have come to know unofficially. How will he put it on affidavit? I'm not on that. But the who must come up some conclusive finding.
Conclusive finding. Without that, my lord, nobody can say that this is the acquisition portion. If your lordship will see my affidavit, my lord.
So, if any encroachment happens and ultimately
no encroachment happens, I can't say that the encroachment happens.
I am not saying encroachment has happened in this case. I am not saying. I am saying that if somebody encroaches, take a situation.
And my lord,
he encroaches a land, and then
in every case, my lord, we have given the report to that effect.
Then conveniently the records are misplaced. Conveniently.
My lord, I can't understand.
Conveniently the records are misplaced. So nobody will be able to say it is encroachment.
That is not the position of law, my lord. In every case, we have given demarcated the land and said that that is the encroachment. And
Sir, every land has to be owned by somebody, either by an individual or by the state.
My lord,
or by the state.
My lord, whether this path is acquired, how much portion was acquired, that is in the mother acquisition. In the but in the through the in the office of the assistant engineer, there is no any such
right. So who is the appropriate authority?
That is the ADM, my lord. ADM, he wrote a letter to the ADM to give me the copy of the LA, whether this portion was acquired or not. That was not given by the additional district magistrate LA for up till now. So it is not possible for BLRO.
I appreciate it is not possible by assistant engineer. I appreciate.
And BLRO, my lord.
I appreciate by BLRO and assistant engineer. Then who shall have to give? Who shall be assess it?
That is the ADM LA, my lord. LA map. LA map was kept by the ADM LR, ADM LA, or my lord, the respective office.
Very well. I am directing, I'm recording your submission and directing both the BLRO and this PWD assistant engineer to write a detailed letter to the ADM.
ADM, I have already asked an
And
engineer
you
already.
produce those before this court on the next day.
My lord, I have given the, that document is there, my lord. If your lordship will see this.
Page.
Lordship, on the day of the field inspection, if the ADMLA produces the Moja map to the concerned BLR, the entire matter gets resolved, Your Lordship.
Show me the letter.
Yes, ma'am.
Lordship, I think page 20. Page 20.
Page 20, my lord, my land said.
See to it, see to it.
Yes, my lord, page 20.
But no reply has come
My
to
lord,
this letter.
11th April, my lord, that is 2020.
So no reply has been received. দেখুন আসুন Mohammad Jishanuz Zaman, learned advocate, appears for the petitioner. Mr. Chondi Charan De, learned additional government pleader, with Mr. Anirban Sarkar, learned advocate, appears for the alleged contempt. Mr. De has filed, learned advocate for the alleged contempt number 1 has filed an affidavit affirmed by the alleged contender number 1, BL and LRO. Oh,
this is content number 2.
Oh, alleged, sorry.
Added contempt number.
কি বললাম?
Added contempt.
2. Two. না কি বললাম? The same is taken on record. Copy has been served to the learned advocate for the petitioner in court today. Today?
Yes, madam.
Today in court.
Yes, madam.
You have been served. Posted. Referring to a letter dated paragraph, referring to a letter dated April 11, 2025 at page 20 from the said affidavit. That an additional government pleader submits that despite this letter being issued by the office of the alleged contemner alleged added contemner number 2, alleged added contemner number 2, comma, till date, no reply has been received. Neither any information has been furnished. He submits that in absence of such information and particulars, the alleged added container number 2 or the alleged container number 1 cannot proceed a single step. In view of the above, it is expected that the additional district magistrate land acquisition, bold করবেন, the additional A cap district D cap magistrate M cap bracket land acquisition L cap A cap এ পুরো বোর্ড চলছে, South 24 Parganas, Alipur. For about last 7 months, during the last 7 months, during the last 3 months, should have replied to the said letter, to the author of the letter. But unfortunately, the same has not been done. Paragraph. It is further, this court expects that the said letter should dated April 11, 2025 should be replied by the additional district magistrate land acquisition South 24 Parganas to the executive engineer, PWD, South 24 Parganas, being the author of the letter, with all the relevant materials, with all the supporting relevant materials, along with the copies thereof. Positively within a period of 2 weeks from the date of communication of this order. First paragraph. Both the learned advocate on record for the petitioner and the learned additional government pleader and the office of the learned additional government pleader and the office of the learned additional government pleader shall serve a copy of today's order upon the alleged contemners and also upon the additional.
I am representing both the contemners. I am representing both the contemners. So that.
ঠিক আছে, তাহলে কি বললাম? Shall serve a copy of today's order upon the additional district magistrate land acquisition within bracket land acquisition South 24 Parganas. এই যে এইভাবে লেখা দেখুন, এই দেখুন উপরে কোণে দাগ দিয়ে দিই। The alleged added container number 2 shall file a further short affidavit in this regard, communicating the progress in the matter, further progress in the matter before this court on the next day. Paragraph. The matter shall appear under the heading Contempt application on September 19, 2025. ভালো মনে হচ্ছে সেপ্টেম্বর 29-এ আর রাখবো না কিছু। কটা আছে? হ্যাঁ, 8টা আছে, আর রাখবো না কিছু। 29 সেপ্টেম্বর অগস্টে কন্টেম্প কিছু রাখবো না। I'm coming within 10 minutes.
I am for the applicant, my lord.
I am for the alleged contempt.
Well, just now, my lords, I received the compliance report, my lord.
Compliance report.
My lord,
You take time sometime.
my lord.
Mr.
S.K. Shahjahan.
S.K. Sheikh Shahjahan. S.K. full stop Shah Jahan. Learned advocate appears for petitioner. Mr.
Mr. Shubhajit Chaudhary. Shubhajit Chaudhary.
Shubhajit
Yes.
Chaudhary.
Yes.
Learned advocate appears for
Alleged contempt number.
how many? How many are there?
One.
One contemner.
Only DM.
Alleged contemner. Paragraph. Learned advocate has filed देखिए a compliance report in the form of an affidavit full stop. The same is taken on record. Stop. Copy has been served upon the petitioner's advocate today in court. But the reasoned order has been passed.
Yes, my lord.
Reasoned order has been passed.
Passed, my lord, but
But what instruction you will take?
there is some
Because you cannot challenge the reasoned order in contempt. Even if the reasoned order is totally bad, then also you cannot challenge it in contempt. Then what instruction?
kindly give me a liberty, my lord, to challenge it before.
It is always there.
They must dispose of it on.
Ah,
Draft to
কি
dispose.
বললাম? The report shows that the reasoned order has been passed on July 3, 2025. Kindly come to the last paragraph. It's in your favor.
Considering the above
Read page 3, considering.
Considering the above facts and
Louder, louder.
Considering the above facts.
Take the microphone.
Considering the above facts and circumstances, it is hereby ordered that the road has been constructed over the vested land and over the existing Moram Road unpartitioned land used by the local villagers for long ago. So the petitioner's allegation is baseless, and also the prayer for remeasurement of the said land is hereby rejected, and the block land landing officer Agra 1 is directed to take the possession of the vested portion of land being plot number 3737 encroached by the petitioner unauthorizedly. My lord, that plot, my lord, I am the Rayat.
So that is, you have to challenge this order. That is not doing contempt. কি বললাম? Poster. The correctness and quality of the reasoned order cannot be looked into in a contempt proceeding. Paragraph. Accordingly, nothing further survives in this contempt proceeding. Poster. If the petitioner is agreed with the impugned order, the reasoned order, it will be open to take recourse of law. Paragraph. Accordingly, CPAN bold 373 of 2025 stands dropped, bold, and normal closed bold. Dropped and closed. Paragraph. The application CPAN 373 of 2025 bold stands disposed of.
My lord. Great. Great.
I am for the petitioner in this matter.
I am for the alleged contempt.
There is an order passed by your lordship.
Take the microphone.
There is an order passed by your lordship on
3rd of October 2024.
Let's see the order.
Page 18 of my contempt application.
18.
18, 1-8.
In the event, the reasoned order. Come to page 15. Read in view of.
Page
15. Order dated November 20, 2024.
No, this is 3rd of October 2024.
First, come to the main order.
Yes.
May I shortcut? Two order has he has filed a writ petition. I have filed a writ petition. He, my lord, shall pay
Contempt arises from which order?
My order. My lord,
His
my
3rd October.
Don't say anything further. First, you show me the order from which contempt arises.
3rd October 2024. Page 18 of my contempt application. 1-8. After the affidavit page.
It is not.
My lord, he has filed an application for
wait.
Application for addition of party.
Page
contempt
11.
application.
Wait. 3rd October. 3rd October.
3rd October.
Read on.
I have not annexed in my contempt application with regard to my 22nd of October order.
Kindly come to page 12, top. Read on.
Page 12.
12.
Order
Page 12, top.
that we can do.
Well, your lordship was not seen his application for addition of party, not my.
Sir, order is the same. How does it matter? 3rd October.
Because I have not served to the can application.
Forget it. You place from your application.
Page 18, well, page 18, kindly page 18.
Okay, wait.
Page 18 of my contempt application.
Okay.
Portion. কোর্টের কাছে মিথ্যে কথা বলে দিচ্ছিস সার্ভিস হয়ে যেত কি মিথ্যে কথা বলে দিচ্ছিস
You have not been served.
Yes.
Application for addition of party, yes.
Then what else? I was asking from that page.
I do not know, my lord, whether any application in contempt application for addition of party is lie or not.
That's a different issue. You have said you have not been served.
Yes. তো শালাবা উঠে
Served, my lord. It was served, my lord, to my clerk, my lord. I could not.
To your clerk. So tomorrow your clerk will appear.
No, you also kindly come to page, my lord, 3rd October order.
Yes.
Yes. Or page 18 of my contempt application.
Yes, please.
So Lokinath Bharti, learned advocate.
Look at it. The petitioner's complaint.
Complaints of alleged unauthorized construction and encroachment on a portion of a PWD land at the behest of the private respondent. The petitioner submitted a representation dated August 27, 2024. The respondent number 11, upon notice to the petitioner and private respondent, shall cause a physical inspection of the alleged encroachment on the PWD land and shall prepare a report. Copy of the report shall be submitted to the petitioner and private respondent and respondent number 8.
Full stop. Done. Physical inspection done. Report prepared. Report submitted. Then next paragraph.
The exercise shall be carried out by the respondent.
It is done. Next, respondent number 8.
After receiving the said report from the respondent number 11, upon issuing a prior hearing notice of at least 7 days to the petitioners and private respondent, and after giving them an opportunity of hearing, shall dispose of the representation dated August 27, 2024 by passing a reason order in accordance with law.
Done or not done?
Done.
Next.
This exercise shall be carried out within a
required. It is made clear that
court has not gone into the merit of the rival contention.
In the event. Next, in the event.
This is vital, my lord. My lord, kindly come to my lord earlier paragraph once, my lord. It is made clear that the court has not gone into the merit of the liable contentions of the petitioner and private respondent, and they shall be free to urge whatsoever points they shall be urged by the rely upon whatsoever records and documents they wish to rely upon before the respondent number 8. But the same shall not travel beyond the scope of this representation dated August 27, 2024 as referred above. My lord, the reason order was passed My lord, that is absolutely, my lord, beyond the representation of 27. My lord, may I just only one thing, my lord, he has filed an affidavit in compliance. My lord, kindly allow me to take an exception to the report. My lord, kindly give me a chance.
No, you first show me that it was beyond.
Beyond, my lord, what is happened? In the
Your happening will not do. Show me and.
My lord, when a contempt application was filed, the order was not passed. My lord, the contempt application.
Place the complaint.
My lord, the contempt
Your
application.
compliance report.
Three complaints report, three contemptness.
That was
Wait.
subsequent to the contempt.
One top.
Wait. Mr. Lokinath Bhattacharya, learned advocate, appears for the petitioner. Mr. Pankaj ওটা পরে private তো?
No, common order has been passed by the SDO under section 10.
No, forget it.
Malad, the
Serial number?
No, there is no one here.
Serial number?
Malad N1 2025.
CPAN 555.
My contempt.
His contempt.
You are
intervening of that application.
All right. Mr.
Srinath Singh Rai.
Srinath Singh Rai, learned advocate, appears for alleged
Complaint number one.
alleged contemners.
Three
All three. Alleged contemners. Mr. Pankaj Haldar appears for intervener applicant in Can 1 of 2025, seeking to intervene in this contempt proceeding. Full stop. The said intervention application has not yet been considered. Paragraph. At the threshold, this court is of the opinion that it shall consider first the contempt application.
Yes,
Yes, Mr.
May I get a compliance report?
Yes, তুই তো এটা পেয়েছিস।
তোকে বলছি না, ও মাথা খারাপ করে দিল।
আচ্ছা, এবার লিখুন, on the prayer of Mr. Srinath Singh Rai,
আরেকটা দিচ্ছি।
the compliance reports in the form of affidavits filed by alleged contemner number 1 and 2 are taken on record. Full stop. Copies have been served on Mr. Lokinath Bhattacharya, learned advocate for the petitioner in court today.
I want to use a affidavit.
Please. Not as of right in contempt. First, I will have to see.
Yes.
It's not as of right in contempt. Full stop. Mr. Srinath Singh Rai has also submitted a compliance report through a forwarding letter dated July 2, 2025, issued under the signature of the alleged contemner number 3, subdivisional officer.
Diamond Harbour.
So, oblique subdivisional officer, comma, Diamond Harbour. Full stop. The same is taken on record. Full stop. Copy has also been served upon the learned advocate for the petitioner. Show me the reasoned order. Show me the reasoned order.
Just 1 minute.
বসে পড়ুন।
My lord, page 5 of the sub-judicial officer's compliance report. Page 5.
Full stop. লিখুন, page 5, paragraph. To the compliance report of the filed to the compliance report filed by the alleged contemner number 3 is the reasoned order dated
Page 10, my lord. I am sorry. Page 10.
Is the reasoned order dated July 2?
Yes.
July 2.
July 2, 2025. Passed by?
Executive Magistrate Diamond Harbour, South 24 Parganas.
Passed by the alleged?
Contempt number 3.
Alleged contender number 3. Executive Magistrate?
Yes, my lord. Diamond Harbour.
Subdivisional officer, it is written.
Subdivision. Subdivision officer Diamond Harbour.
But the reasoned order passed by whom? Executive Magistrate. কি বলছে? Kindly come to the reason, my order. Have you read it?
Yes, my lord.
What? Who is supposed to pass the reasoned order?
Alleged container number 3, subdivisional officer Diamond Harbour.
Kindly to come to page 18, my order.
The respondent number 8, after receiving the said report from respondent number 11, upon issuing a prior hearing notice to the exercise shall be carried out and completed by the.
Who is respondent number 8? Bosun. In the writ petition?
Page 20, my lord. The respondent number 4. Respondent number 4 is the subdivision.
What was my order?
Eight assistant engineer.
I'm saying, sir, you.
4 subdivisional officer, 11 BLL.
Who was supposed to pass this reasoned order according to my order?
Respondent number 4. Then shall take.
Kindly come to page 19.
19, my lord.
What does it say? Chechi, be louder.
Respondent number 8, after receiving the said report from the respondent number 11, upon issuing a prior hearing notice of at least 7 days to the petitioners and the private respondents.
Yes.
And after giving them an opportunity of hearing, shall dispose of the said representation dated August 27, 2024 by passing a reasoned order in accordance with law.
So who shall have to pass the reasoned order?
The assistant engineer. Assistant engineer Joynagar.
Respondent number 8.
8.
Assistant engineer.
Yes, madam.
Who has passed this reasoned order? Show me. Show me that reasoned order.
My lord, I have given your lordship the second contempt compliance report, that is assistant engineer. There are 3 compliance reports, my lord.
Yes. So show me.
Second compliance report.
Yes. Show me.
No, comply. Dedi.
Mr. Bandyopadhyay, take up. Waste of time.
Third January 2025. এইটাই এই অর্ডারটা দিল।
এটা হচ্ছে বিএলআর কমপ্লায়েন্স, যেটা আপনার হাতে আছে। উনি চাইছেন অ্যাসিস্ট্যান্ট ইঞ্জিনিয়ারের রিপোর্টটা দাও তাহলে। হ্যাঁ, দেখছি দাও।
Kindly come to page 21. Is this November 22, 2024?
3rd January 2025, region order passed by the assistant engineer.
Page?
My lord, I have not been, but I paper an appeal, statutory appeal, I have annexed this, my lord, this order. এইতে যেটা বলতে চাচ্ছি রিজন অর্ডার অ্যাসিস্ট্যান্ট ইঞ্জিনিয়ার না আমার আপনাদের কমপ্লায়েন্স রিপোর্টে তো থাকবে এই কপিটা দেই এই তো রিজন অর্ডার
You don't carry your brief?
Yes, my lord, I have only one copy. I have given him.
তোমার brief কোথায়?
এখানে তো
মুশকিল।
এটাই তো
তোমার brief
ওটা
তুমি
একটু
receive
জাজকে তুই সাহায্য কর তোর কপিতে একটু সাহায্য করে দে একটু দিয়ে তুই একটু সাহায্য করে
কপিটা ওকে they have annexed তুই বল they have annexed another reason order that is at my lord page
এই লক্ষ্মী আমার কাছে
ওটা দিয়ে
21 of the my lord the
I have seen that. You show me that order first. কিছুই জানবে না এই কি বলুন তো
yes lordship correct
I better call upon them. Mr. Bandyopadhyay, I'm calling upon these officers to be present.
This matter, well, I don't know what is the matter. You also take up another date minute. I'm not ready. I'm not.
Unnecessary 40, half an hour time is wasted.
Copy কোথায় নেই কিছুই নেই রেডি
He will not know which page.
একটা কপি ছিল ওকে
একটাও কপি তুমি দেবে কেন তোমার কাছে কপি এক্সট্রা করোনি কেন লক্ষ্মী ওটা দেখ পরে জিজ্ঞেস করে আগে দাওনি কেন
কপিটা এই কপিটা দেখেই হয়ে যাবে আজকেই হয়ে যাবে এখানে রিজন অর্ডারটা উনি দেখতে চাইছেন হ্যাঁ এই যে রিজন অর্ডার এটা রেসপন্ডেন্ট নাম্বার 2 তো
Yes, sir, I'm on respondent number. Page 21. Yes, I was asked that. I have asked it, showing that November 22, 2024.
The hearing of following has been recorded. After hearing following revision order, he has been passed.
Page
23. It is clear from the inquiry report that there are unauthorized occupants that is for number 570. Specified as
Very well, very well. Then kindly. Kindly come to page 20 of the content application.
Page 20.
In the event, read on.
Order compound the encroachment and PWD can then the respondent number 8 shall report to the respondent number 4.
Very well. Has this been done?
Thereafter, my lord, this notice, my lord, has been given. Page 12 of my the compliance report.
No. Then has it been sent to respondent number 4? Show me.
My lord, PN1 notice has been demanded issued thereafter. That is of 75.
PN1.
Then what happened? Respondent number 4 did what? Respondent number 4 means your 2. Your 3.
Subdivisional location.
Alleged container number 3.
এটা বলে দে না পেজ 12 বলে দে না
Page 12.
এই তো 12 পেজে এই তো পাঠিয়ে
13 pages.
তো বলে দে ওনার কাছে গুলিয়ে ফেলেছে তুই একটু যা ওটকে চাইছি এটা বলে দে না
Page 13, he has sent it to the SDO. Then what did SDO do?
Executive magistrate passed an order.
Executive magistrate. Why executive magistrate in case of SDO?
Same power, my lord, SDO and
Executive magistrate. Yes.
And
Yes.
2nd of
yes,
July.
Yes, yes, yes.
It is.
Show me that order.
That is not your loss, 2nd of July order.
Third report which has been handed over.
Page 11 of the report.
That's I will have it.
Page 11 of the report.
My lord, the report dated 2nd July.
I have seen, sir. Page 11.
Page 10. Page 10, my lord. Page 10. Sorry, page 10
Page 10.
of the report.
Yes, 2nd July.
2nd July.
So where is the contempt now? Show me.
No, my lord, your lordship was, my lord, first of all, my lord, your lordship was kindly come to the lordship's order. That is at page, my lord, 2020. The third paragraph.
Have you preferred any appeal under 10.4?
My favor. It is against him.
Against him.
Against him.
Matter ends. Where is the problem?
Kindly come to, my lord, the respondent number 4. Then shall take necessary.
If page 10 is in your favor, if page 10, kindly come to SDO's order is in your
my
favor.
My lord, yes, they have detected.
So where is the contempt?
Well, there is a detector with regard to, my lord, the alleged encroachment made by the private respondent. My lord, on the basis.
It is confirmed.
It is confirmed, and my lord, the 10-3 proceeding was concluded.
Right.
Now, my lord, you will also kindly come to page 20.
Where is the contempt?
My lord, the consequential stress with regard to removal is not yet been done. This is past. And second thing is that your lordship was specifically directed not to go beyond the representation of 20th of August.
So you want to reopen all these?
No.
Again.
No. I am just.
I'm recalling all these orders. I will hear your contempt. Chalo. I'm recalling all these orders. I'll hear your contempt. The first stage, you want to reopen.
No, I am not reopening. Your lordship was directed to go on the basis of my representation. Well, in the representation, I have made 14 encroachers names. Well, they have been detected as my lord, the and we found one encroacher.
Then 2 steps further has taken place up to SDO's order, which had gone into your favor.
Yes, my favor.
Then where you are still want to reopen?
In respect of my lord, my name was included in the. I have my lord.
That's a different challenge, not in contempt.
In the representation, is not my name was there, but my name, my name was there. My name was included. And my lord, the consequential steps is my lord with regard to removal. That was not yet been my lord done.
Now it is in the.
Well, the SDO passed an order. You also kindly see within 15 days they will the directed to.
That is not. I'm not there on contempt to look at the SDO's order.
You will also directed the SDO to take consequential steps immediately.
Yes, he has done so. He has done so. He has passed his order. কি বললাম? Sir, litigation fine for the sake of litigation. That also I don't mind. But there must be some limit of a vexatious litigation.
No, after contempt application, the order was passed. It is not that during pendency of the contempt.
Yes.
After serving the contempt.
Correct. Correct.
The order was passed.
Correct. And up to that stage, it is fine. Now you are saying that they have not considered my representation in its full form. After that, 2 steps have been taken. I'm recalling all these order. Again from 0, your representation will be considered in its true spirit and word. You are agreeable?
No.
Then why you are making this submission?
I am just seeking your lordship to leave to mention that only point that since I filed a writ petition, I have been implicated.
All right. কি বললাম?
That is my only fault. I filed a writ petition.
আমার কেসে তোর নামটা ঢুকেছে
বলুন একবার। The order dated October 3, 2024. Annexure P1 at page 18 to the writ petition, to the contempt application, where from the content proceeding arose broadly has the following parts. Broadly had the following parts. Roman 1, colon there. The jurisdictional block land and land reforms officer, bracket BL and LRO, was directed to cause a physical inspection and to file a report. Semicolon, Roman 2. Upon receiving the report, the assistant engineer PWD was directed to give a hearing and decide the representation of the petitioner alleging unauthorized and illegal construction by passing a reasoned order. Semicolon 3. In the event the reasoned order confirms encroachment on PWD land, the respondent number,
ওই যে দুটো কপি আছে, তুই একটা কপি একটা, এটা আমার না, না এটা নয়, উপরে একটা।
subdivisional officer, upon being communicated the same, to take all further steps in accordance with law. Paragraph. The compliance report, now page 20, annexure B at page 21 to the compliance report filed by the alleged contemner number 2 shows that a reasoned order dated November 22, 2024 was passed by the alleged contemner number 2.
Container number 2, page 8.
Container number 2. The alleged container number 2, after confirming the fact that PWD land was encroached, had sent the reasoned order before the alleged container number 3 by a forwarding letter dated
forwarding letter বলে দাও।
4th June 2025.
Page
13 of the 13 of the instruction.
The instruction এটা বলে দে না।
But এটা the instruction too. Page 13.
Wait.
Page 13 of the instruction.
কি বললাম? June 4, 2025. Annexure B at page 13 to the compliance report filed by the alleged container number 3. The alleged container number 3, then passed its reasoned order dated July 2, 2025 at page 10 to the said compliance report filed by the alleged container number 3. Post. Paragraph, this court has been informed that the interveners, this court has been informed by Mr. Pankaj Haldar, learned advocate appearing for the interveners in Can 1 of 2025, that the said proposed interveners, have preferred an statute.
My submission before your lordship, we have been served. My lord,
Sir, have you carried any appeal from this?
alleged encroacher, my lord, filed a statutory appeal serving the notice upon me as well as
He will submit that he alleged that the encroachers have filed a statutory appeal from the said order dated July 2, 2025. Full stop.
As well as my lord, another my lord, writ petition before this honorable court.
Full stop. দরকার নেই আমার লেখা। This is in contempt. Full stop. In view of the above, now full stop. In the above facts and circumstance, comma, Mr. Lokhi Nath Bhattacharya, learned advocate, appearing for the petitioner, submits that none of the alleged contemners have complied the direction of this order and have deliberately and willfully violated the direction of this order, passed by this court. Petitioners, passed by this court. Referring to the said order of this court dated October 3, 2024, he submits that the representation of the writ petitioner dated August 27, 2024 has not been considered in its true spirit and effect, and the authorities have gone beyond that. This is your submission?
It's not my content, sir. My name was included.
Where?
In the list of the encroachers. In the representation, my name was not there. But
that's right. By including the name of the petitioners in the list, 8 petitioners.
The petitioner number 1, only petitioner 1 was.
Petitioner number 1.
Only petitioner.
You don't know even the facts. No, petitioner number 1. Ki bolla? In the list of encroachers, which was not there in the representation. That's your case?
না না ওটাই বলতে হবে ওটাই নেই তো
No. Everything must have limit. Leniency does not mean that you will take advantage of it. I will, tell me, this is your grievance?
My name was not there in LPG.
That's right, I said that. He prays for a further adjudication on this, in this content proceeding. Full stop. Fine. Leniency does not mean taking advantage.
My wrong
All right.
understanding.
हाँ? কি বললাম? After considering the submissions made on behalf of the parties and upon perusal of the materials on record, and in the backdrop of the facts recorded above, it appears to this court that from the stage of the representation of the petitioner dated August 27, 2024, two further stages have already progressed, and the alleged contender number 3 has passed its reasoned order dated July 2, 2025, holding encroachment of PWD road as was alleged by the petitioner in the writ petition. This shows that the reasoned orders at every stage, reasoned orders at every stage have gone in favor of the writ petitioner's claim that the PWD land has been encroached. As the name of the petitioners have been found to be encroachers, along with others, in respect of the encroachment of the PWD land, comma, the attempt has been made to remove the said finding of fact from the reasoned orders passed by the authorities confirming the encroachments on PWD land. Paragraph. In this contempt jurisdiction, the law is well settled. If the court finds any deliberate or willful violation of its direction, the court will hold contempt. And the punishments are prescribed under the statute for the same. The correctness, veracity, or quality of the impugned orders, comma, as in the instant case, cannot be gone into in this contempt jurisdiction. Paragraph. More so, this court is of the firm opinion that since the list of encroachers contains the name of the petitioners in respect of encroachment of the PWD land, comma, an attempt has been made before this contempt court to remove the name of the petitioners from the list of encroachments, list of encroaches in this in the contempt jurisdiction. A clear malafide on the part of the petitioners. Full stop. The plea of the petitioners in this regard is not only vexatious, but also wasting of valuable time of the court and valuable time of the court and
15 দিন হয়ে গেছে চ্যালেঞ্জ করব
full stop. Full stop. Paragraph. In view of the above, this court is satisfied that the direction of this court dated October 3, 2024 stands complied with by the alleged contemners. Full stop. The contempt proceeding, bold CPAN 555 of 2025 stands dropped and closed. Dropped, bold, closed, bold. The petitioners shall collectively pay a consolidated cost of rupees
This is not item, Malad, you'll also kindly appreciate.
consolidated cost of rupees 60,000
Kindly, Malad, not Malad, this is not their poor man, kindly appreciate.
in favor of the state legal aid services কি আছে না হ্যাঁ state legal aid services ওই services authority নাকি state legal aid services authority
I can State Legal Aid Services Calcutta High Court
Not pass any order, Malad, kindly, Malad.
state legal aid services authority না কি আছে একটা আরে দিদি
still
আপনি একটু মারুন না গুগলে দেখুন
Malad, this is not the fault of the petitioner, Malad, kindly appreciate.
state
Malad, we will file a contempt application, your lordship's violation of this lordship's order.
state legal
We
aid
can be penalized.
services authority West Bengal positively within a 7 working days from date.
Yeah, we are, Malad, your lordship kindly appreciate, Malad, we file a contempt application
stop.
for violation of lordship's order. And, Malad, they have been violated, Malad, your lordship's order is not
Full
complied.
stop.
State Legal Aid Service City Civil Court
না না city civil court.
my landed senior
This is Malad, kindly, Malad, this is
state
absolutely
legal
harsh.
aid services
This is
authority
absolutely harsh, Malad.
কি আছে কি বলুন না
मतलब the West Bengal Legal Services Authority
West Bengal Legal Services Authority comma কিছু আছে West Bengal বলুন West Bengal
Authority
West Bengal Legal Services Authority কি
Malad,
বলেছে
kindly,
পড়ুন
kindly appreciate, Malad.
from date
Kindly, my lord, this is my lord, your lordship kindly appreciate, my lord. This is absolutely my lord, hard to my
stop.
kindly, not but my lord, your lordship is folded hand, my lord. I am just my lord, your lordship kindly, my lord, forgive me, my lord, once.
Full stop.
Kindly, my lord, kindly forgive me, my lord. With folded hand, my lord, kindly. My lord, this is my lord, absolutely harsh to my client, my lord.
Upon the copy of the money receipt and a copy of the money receipt shall be served upon, who is the advocate on record?
শ্রীনাথ, তোমাকে বলো শ্রীনাথ, তোমার নামটা বলো, অ্যাডভোকেট অন রেকর্ড, তোমার নামটা বলে দাও।
Srinath Singh,
Sir, কি বললো?
kindly appreciate, my lord, mine, I file a
এইটা দেখালে তুই আরো মরে যাবি।
কি
তোর নামটা ইনক্লুড করেছে, এটা মিথ্যে কথা বললি
কি?
কোর্টের কাছে। এটাই আমি দেখাবো।
Shall be furnished
Srinath Singh,
to Mr. Srinath Singho Rai, learned advocate, appearing for the alleged contemners within the said period of time, comma, failing which Mr. Srinath Singho Rai, learned advocate, shall mention the matter before this court.
kindly, my lord, once, my lord, your
Full
lordship,
stop.
kindly, my lord,
Paragraph.
with folded hand, my lord, kindly.
With the above observations and directions, this content proceeding CPAN 555 of 2025 stands dismissed. Full stop. Paragraph. Rule to me, rule to hoy.
No rule.
Kindly appreciate one of the cost, my lord. Kindly, my lord, condone the cost, my lord. Kindly condone the cost, my lord.
বললাম ঠিক আছে, এটা আর্জেন্ট আছে।
Kindly, my lord, condone the cost. Kindly, my lord. The cost is not very heavy, my lord. Kindly appreciate, my lord, this is my fault. Kindly, my lord, consider. My lord, kindly once, my lord, consider, my lord.
অর্ডারের লাস্ট
My lord, kindly consider, my lord.
পোস্ট
My lord, it is appearing for the first time.
From the order dated
18th November 2024.
November 18, 2024. Today is the first day. যা আছে ওই সেপ্টেম্বরে 19 তারিখ রিটার্নেবল। Next. First time. From the order dated
13/1/2025.
19 September. First time. From the order dated
19th September 2024. 19th September 24.
September 19, 24.
Possible to August, my lord.
Next. 13.
My lord, I am appearing for the
First time. From the order dated
order dated, my lord, 25th September 2024.
September 25, 2024. 19 September.
This is my contempt application. I am for the petition.
I am of contributor 2.
Subject matter of the writ application was that the renewal of affiliation a college of Pavititra Fine Arts. Your lordship directed to consider the case. Respondent contender number 2 has considered our case. Thereafter, second part, after considering the case, your lordship directed if the petitioner case is considered, then the necessary fees and necessary renewal fee may be deposited. I deposited the renewal fee, but they did not issue till today. They did not issue the renewal certificate. In spite of the renewal fees. And affidavit in opposition filed by the contender number 1 and supplementary affidavit not maintainable because contender number 1 has no authorized, this is the personal liability. In contempt proceeding, this is a personal liability. Contender number 1 cannot authorize or delegate his power to anybody to affirm any application. That effect there is so there is Lordship your order in the writ application, page sample annexure, page 26, annexure P7.
you will do it today or in the month of September? Because in any event today I will not be able to finish it.
Just
It will take some time.
Today will not finish. Today will not finish.
I will not be able to finish it off.
Well, I have sought submission on this point. I am a contemporary number 2 of the registrar of the university. I was added as a contemporary number 2 in this event. Sole point, a very short point in this point.
I will hear you, sir. If they don't press for the application, how do you bother?
And at present, my main contention is that affidavit in opposition filed by the contender is not maintainable, and supplementary affidavit also filed by is not maintainable.
That and I will hear. That I will hear.
In the contempt, it is a personal liability. He can delegate or authorize any person to affirm any application in contempt proceedings.
Just one
on
thing.
his
What he is saying, just
there is some judgment.
1950.
I will hear you, sir. I will hear you.
Oh,
Why you waste your breath now? Let your turn come. You will place.
It will take time because this very question involved question of law involved.
It will take some time.
Okay.
I appear for the contender number 1.
Appearance গুলো নোট করে দিন। Learned counsel for the petitioner has commenced his submissions and has given a brief outline on the scope of this contempt proceeding. He has taken a point that the alleged contender number 1, comma, in the facts of this case, comma, had delegated an authority in favor of alleged contender number 2.
No.
The present registrar.
He is not the party.
Oh, not a party.
He is not a
In
party.
favor of an stranger to this contempt proceeding, comma, which according to the learned counsel for the petitioner is not permitted in law. This is submission. Full stop. Mr. Pratik Majumdar, learned counsel, appears for alleged contender number 1.
Urunangshu Chakraborty for 2.
Mr. Urunangshu Chakraborty, learned counsel, appears for alleged contender number 2. The matter shall appear under the heading for further consideration, contempt bracket hearing matters.
Number 2.
On September 19.
19, I have some personal
You have difficulty. 19.
Personal difficulty.
No, because this bench will not be there. It will have its circuit.
Yes.
Yeah, my
12,
no.
12 September.
Huh?
12 September. Then you will after 5
Bench will not be available.
Learned senior finishing after the puja vacation.
No, before 19 September.
Why?
No. 19 September is enough.
Why is the contempt
Why
number
you
so
swap on the
interested?
link,
They are contempt.
It is their content.
Conniving. They are
I'm not saying anything.
Eh.
I'm not saying anything.
No, you don't insist for 19th if he has difficulty.
personal difficulty.
All right. কবে খুলছি আমরা দাঁড়া, ও আমার কাছেই তো ক্যালেন্ডার আছে। ও ছেড়ে দে, আমরা এখানে লাস্ট ওয়ার্কিং ডে হচ্ছে 26। ঠিক আছে, হ্যাঁ হ্যাঁ 26 বন্ধ হচ্ছে। First Friday in November, 7th. কি বললাম? Under the heading contempt hearing, ওই for further টা পরে দিয়ে দেবে। On November 7, 2025, comma, as paid for on behalf of the petitioner. You can prepare one notes on argument also. In the meantime, you are getting
I'm
long
already
time.
prepared.
Very well, very well.
I can hand over right now.
No. Keep it with you, sir. Why will you? Let your turn come.
I have no allegation against the contender. I have no allegation against the contender number 2 because he has considered as per.
And then why you are implemented him? Expunge him. Make a prayer for expunging contender number 2.
What happened after your lordship passed the order? Lordship passed an order for consideration. Now the content number 2 passed a reasoned order giving the affiliation. It was
very well. We will consider.
And because of this affiliation, giving affiliation is one of the charges in the charge sheet for which he has been dismissed from service.
A person has not gone through the Renewal Act. Act says there is a provision for giving affiliation. In fact, contempt initiator of the
affiliation, affiliation cannot be granted.
Act is very clear, my lord. Act is very clear.
So it is. I mean, you enjoy the fight between these two alleged contenders. Why you are bothering? Let them fight between themselves.
My lord.
Don't bother. You stick to your case. Matter ends. Application for
Restoration.
delay,
Within 4 days, I have filed.
no delay. Ashu. Should I look into it or not? No delay.
Within 4 days.
This is an application. Yeah, Rushikata বুঝতে সময় নেয়। Can one of
2024.
2024. Paragraph. This is an application for restoration of a writ petition which was dismissed for default on July 4, 2024, bold, and the application has been taken out
On
July 8, 2024, bold. Full stop. Sufficient cause being shown. The order of dismissal dated July 4, 2024 stands recalled. Full stop. The writ petition stands restored with its original to its file. Restored to its file with the original number. Paragraph. Accordingly, Can 1 of 2024 stands allowed.
State is represent.
With allowed with
Some cost.
Honorary worker.
Well, I am for the state response. Response number 1 to 5,
Kindly
9,
fix
10,
the
and
date
11.
of hearing. Lots of the motion stage is very short matter. What's the kind next month
Well,
list of
other
August?
person, those are not represented. Well, there has to be.
হাসছিল এখন গম্ভীর হয়ে গেল।
What's the month list of August?
চলো next.
Lots of kindly. Lots of again I have to bring the file.
থামতে হলে আমি বলবো, you call on.
Your Lordship, this is an application for appropriate order. Since
Show
the
me.
beginning, Your Lordship, nobody is appearing for CSTC. Actually, Your Lordship, this matter relates to non-payment of my provident fund. I have given, on hearing, Your Lordship, have given the order, usual order. But due to the typographical mistake of the stenographer, some other order has been typed in place of my order, Your Lordship.
Huh?
Lordship, kindly see the order. The order passed by my lord on 22nd of June, 22nd of May. My lord has passed an order, but that was not the order which I have handed over to your lordship. The name of the learned counsel was also different. This is my affidavit of service, your lordship.
Where is my order?
Lordship, kindly see your lordship.
22nd May.
May 2025.
One second. Wait. Who normally appears?
Appears for CSTC, Mr. Bihani. But he
Give him a
lordship have given notice on repeated occasions.
asking you to give another notice. And the junior who regularly appears. The junior, some
Shomojit Ghosh.
whoever regularly appears.
Given
This order, I will not recall ex parte. It may be a mistake on the part of the court, but in their presence, I will do the needful.
Lordship, actually, when this matter was heard, originally, your lordship, nobody appeared on behalf
I
of the
know,
petition.
I have seen that, but still I will,
Lordship, I will do that.
without their presence, I will not touch.
Lordship, that's why I have given the notice to the managing director, but they refused to accept.
Forget it.
But they
I will very well. Ask.
Lordship, kindly give them the direction to serve the learned counsel, I will.
I will not. Yes, that I'm doing.
Lordship.
Affidavit of service filed in court today is taken on record. The plea of the petitioner is that the order dated May 22, 2025, by which the writ petition was disposed of, due to some typographical mistake, though the number of the writ petition and the cause title is of this writ petition, but the entire order, but the relevant part of the order has been typed out erroneously without any correlation of the case made out in the writ petition, without any correlation of facts mentioned in the writ petition. First paragraph. The record shows that the order was passed when the answering respondent CSTC was not represented. Through the instant application, the petitioner prays for recalling of the order and to pass the necessary and appropriate order in the light of the case made out in the writ petition. Paragraph. Considering these circumstances as narrated above, comma, and considering the fact none appears for CSTC event today, comma, despite notice, comma, Mr. Noinchand Bihani, learned senior advocate, along with Mr.
Shomojit
Ghosh, learned advocate, who normally appear for CSTC, are requested to appear in the matter, comma, hold the brief to assist this court henceforth. Paragraph. The petitioner, learned advocate on record for the petitioner shall, paragraph again. Their appearance shall be regularized by the appropriate authority of the CSTC. Paragraph. 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 Learned advocate on record for the petitioner shall serve a copy of the writ petition along with a copy of the instant application and a copy of today's order upon Mr. Bihani, learned senior advocate, full stop, comma, to enable him to obtain instruction from his client. The matter shall appear under the heading application on Ajit August 8, 2025.
First, my lord, I have to begging unconditional apology because the records actually pertaining to that is the instant case was not disclosed because at that point of time it was not there. Subsequently, they found documents. Before the Malad need not look into that. Malad, give me just 5 minutes.
It's a review application.
Review as well
Let's
as
file affidavit. Ashu.
If your lordship sees
Point of maintainability.
whether it is extraordinary,
Point of maintainability.
yes, kindly seize your lordship's order, kindly seize.
Come with an affidavit. Because what he has submitted, this is the plea in the application.
The document now he is making for review already on record in the main proceedings.
That's right. Main writ petition.
Already I can show this document.
Main writ petition.
Correct.
Come up with an affidavit, say that, let him say what is there, what is not there. Ashu. This is an application for review of an order dated 11 November 4.
One minute I'm taking. If you lordship kindly seize the order itself.
then Malad, I will start. Malad,
Wait, sir, I have not disturbed you.
Yes.
Please wait. Hold your tongue.
This is my application.
Let us come to the order itself.
Yes. Tell me.
My lord, if your lordship kindly come to the order, I am reading.
Is there any condonation application?
It is not required. Well, now the division bench delivered a judgment where I appeared on behalf of the state.
So the Limitation Act provision is gone.
Limitation is not applicable, so for review is
review in writ.
Yes,
review in writ.
Well, that judgment I have, I can produce. Well, that's why I kindly make an affidavit.
All right.
No, kindly, I'm just 1 minute, I'm taking. May I read at 26 page? Today, Mr. Chandicharan De, this is in respect of the earlier order. Learned additional government filed a report. In the report, all these documents were disclosed. Land acquisition officer taken on record. Ankita Chaudhary, Learned Counsel, led by Ms. Monica Roy, Learned Counsel appearing for the National Highway Authority India, files a report also. Learned Counsel for the parties, kindly see, are addendum that the revised enhanced award of compensation dated June 30, 2016 was passed in the quantum is lying with the respondent.
Was passed?
As per arbitrator award dated 30th June 2016 was passed and quantum is
what was your claim in writ petition?
A claim in this writ petition in respect of the enhanced quantum as passed by the arbitrator.
What you were not happy with the enhancement?
No. I was happy. That is why on this consensus that enhanced awarded amount is to be paid to me.
So why the writ petition? Amount was not paid.
Enhanced amount was not paid. In terms of the ex parte arbitral award, I did not got any chance to make any further. Even then, that is binding.
You have accepted the award.
Yes, correct. If such acceptance is there on this item, both the council says is enhanced money which is to be paid to me already lying in the custody of the disbursing authority. On that score, it has been passed. So question of review, consent, I believe it is decree, if a consent decree is there, subject to correction. So question of review does not arise at all. Why they are anchoring? Because this is a payment to be done in the year 2018. Now, since your lordship passed the order in respect of statutory interest after 6 or 7 years, that provoked them to file this review. That is why whether review is there. In view upon compliance of all formalities, petitioner is subject to it shall collect their. So I believe in twofold way, it cannot be said to be a judgment which can be reviewed if things it is a judgment on consideration Order 12 rule 6. If I get the provision of CPC, so appeal under section 90 does not have, or review under section 44.
Sir, when it is in a writ proceeding, the procedure is totally different.
Different, I know this. Or mutatis mutandis applies.
This is a review application.
Because this court person will come and file an I can oppose. I may make an opposition because they are the poor litigant. I do not want them to come since 2018. Four litigations before this honorable court. Appeal paper, dismiss for default. Then need petition before your lordship. Even then, will review. Kindly cease the agony. And I am feeling for them.
This is an application for review of an order dated November 4, 2024.
Yes.
Paragraph.
My lord, this is the judgment. Section 5.
No, keep it with you.
My lord can keep it in there.
Full stop. The review application has been filed.
এটা লিখে নে এটা
দাও আমি ছবিটা তুলে নিচ্ছি
আরে নে ছবিটা তুলে নে
কি বললাম on July 2, 2025 এটা bold প্রথমে অর্ডারের ডেট bold এটা bold paragraph considering the nature of the application, Mr. Bishwarup Bishwas, Learned Counsel for the respondent writ petitioner.
Applicant petitioner, but I file a contempt also. After filing a contempt, they are filing review.
So if you were respondent writ petitioner.
Yes, my lord.
কি বললাম তো ভুলিয়ে দিস
Sorry.
কি বললাম
I tender apology for that.
Writ petitioner has raised the point of maintainability of the application. Full stop. The same is kept open. The same shall be heard first when the matter shall be taken up next. Paragraph. Respondents shall file affidavit in opposition on or before আজকে তারিখ 25 August 1,
As you know, sir.
August 1, 2025. Reply, if any, thereto shall be filed by August 14, 2025. The matter shall appear under the heading Application bracket A hearing. কবে নিয়ে আমরা অ্যাপ্লিকেশন আচ্ছা কবে বললাম ওটা 18 বলেছি তাই তো August 20, 2025.
Some prior.
August 20, 2025. Yeah.
Now the matter is over. Now, my lord, I am making on humble submission.
আগে I think that.
Yeah, that's right.
Tapas Kumar Mukherjee on our Barasan room number 2. Just inside of, beside of just senior advocate Sudhish Kumar Das.
Howrah?
Yes, I believe, no, Tapas Kumar Mukherjee expired. Not from Howrah, I believe from Central Calcutta. Just,
My lord,
it's just beside.
You don't recognize that person. I know. Because
Very knowledgeable person. We have learned from him a lot regarding civil aspect.
So what will be the age around?
80.
Oh, no.
Above 80.
Above 80.
Obliged. But I will make my humble submission at the time.
You are always humble.
Regarding maintaining.
You are always humble, are you not?
That is my lord, that is the privilege we are getting. Well, not me also, everyone.
Oh, Lord.
Obliged.
And because of the leniency, you are filing this.
Yes.
That I also can say. That I can say. My lord is showing too much leniency.
No, because today afternoon, I also dealt with the leniency. Today afternoon, you were there.
14.
That I don't know. I awarded cost.
Yes,
Contempt.
I was here.
I said leniency does not mean taking
Your
advantage of the.
lordship judgment I have. Division mein,
Here also same fate may happen.
I'm obliged to. Nothing to say. I shall not open my mouth.
Is a fraud
I
that
shall.
is upon by the petitioner.
All
But
right.
I will make something.
ঠিক আছে চলো
Yes.
But 20 I am for the state. I think 20 I am for the state.
Respondent.
Yes, state.
Your Lordship, I am for the, there are two analogous matter, Your Lordship. 2021. That's my submission from 21, Your Lordship.
No, 20, first 20 is 20 I have submitted report, my lord. Kindly start from 20. It's 20 job.
I don't mind hearing anyone.
Yes, because my 20 I have dealt with this my personal lordship's order. Past in item number 20, I have dealt with the matter.
Survey. If I start with item number 21.
So 21, there is no report.
No, they filed the report and I have filed the reply of the report, Your Lordship.
21, I am not the.
21, you have filed report.
No, I am not in the 21 matter, madam. These
Two analogous matter.
He is not there, briefed
Not
in
there.
21.
আপনি কত? 21 is absent, Your Lordship. Each and every day. 20.
How can I? The respondent is not there.
Should I proceed? Your Lordship? Should I proceed?
In 20.
I have to place my submission from 21. It will be
Why
here.
not?
I don't mind, but you bring the other side then.
Yes.
Bring the other side.
Because 20 minutes I have elaborately dealt with the matter. He has no case at all.
He is doing so.
Huh?
He is not presenting each and every day, Your Lord.
No.
So you get ready on 20 and do it. Get 20 decided, you place 20.
Lordship, it is analogous and it is.
You are also not, you are also not,
Still my submission from
you,
21.
you are also not ready in 20. Get ready in 20. Come tomorrow. Next day. Passed over for the day. Get ready in 20. Do it in his presence.
Yes,
Whatever may happen, the result will follow.
yes,
But
that
for
is.
analogous, I have to
Analogous doesn't mean that.
21. It will be easier to pursue. That is why I can't.
But this is different
Then
matter.
you bring the other side in 21. Next.
What that I am appealing for the petition.
Where is the other side?
Mr. Devashish Banerjee appearing for the High Court administration. In earlier occasion, Your Lordship directed to take instruction if the entire adjudication ballot made by the petitioners were sent to the district committee for taking appropriate steps. For that reason, Your Lordship directed.
Come Monday. It will remain in the list. Passed over.
For item number 23, my lord, it was, I was led by erstwhile, I'm appearing for the state, my lord.
Take microphone.
I was led by Mr. Amitesh Banerjee previously, my lord. Mr. Shishano Bandyopadhyay has been newly engaged in this matter.
Passed over for the day. Next. Petitioner is not there. Passed over for the day. Come prepared tomorrow.
My lord.
Or you also get ready.
My lord.
My Lord, this is the exception. The report filed.
And item number 24, my lord, I am appearing for Union of India. Respondent number 4, 5, and 9.
Ashwin. MS Shetponna Rai, learned advocate, led by Mr. B.N. Roy, learned advocate, appears for the petitioner. Mr. Anup Kanti Poddar.
Union of India.
With
Respondent number 1, 2,
3. Learned advocate with Miss M.S. Anjali Shaw. Learned advocate appears for respondent number 12023.
My lord, I am appearing for respondent number 4, 5, and 9. I am appearing
Mr.
for
Pinaki
respondent number 4, 5.
Bhattacharya, learned advocate through virtual
Union of
mode
India.
appears for respondent number 4, 5, and 9.
9. Yes, ma'am.
With Mr.
My lord, I have no junior in this matter, my lord.
He is not there.
He is my junior, my lord.
Yes. M.S. Roy, learned on the prayer of M.S. Roy, learned counsel for the petitioner. The exception on affidavit filed today in court is taken on record. Yes.
Is the facts in short. Initially, the petitioner was appointed with civil litigation. The advocate position is that by government order, the NAA, that is National Airports Authority of India, International Airports Authority of India, they
International Airport Authority of India.
IAA, National Airport.
Huh? Show me.
This is page 4 of the International Airports Authority. Also employees who were initially.
Show me.
Yes, and this is page 4, paragraph 3. This is an advocate position, but that's why.
I want to know about the authority. Has it been included?
Yes.
Where?
But why with effect from 2nd October.
Has it been included?
See, the Airports Authority is the party center.
Airport Authority is fine, I understand. Who is International Airport Authority? I don't know.
They are not required. They are not required.
International Airport Authority ache?
My lord, there is no existence of international airport authority now.
What I know.
Because initially,
That
like airports,
IAI has been merged with National Airports Authority of India, thereafter with Airports Authority of India.
That's the only authority under the statute.
Yes.
Authority
Acha, now ठीक है, very well. You tell me.
Because all the employees were initially appointed under the Civil Aviation Department.
Take your seat.
By government order, they were in masse transferred from Civil Aviation Department and absorbed under the NAA and on with effect from 2nd October 1989 by government order, and they all became employees of the Airports Authority of India. And the petitioner, on attaining the age of superannuation in the year 2021, he retired as an employee of the Airports Authority of India. But in 2017, the Civil Aviation Department, floated a scheme by which it states that all the employees who were initially employed under the Civil Aviation Department and subsequently must transferred to the Airports Authority of India and who has served less than 10 years, they will come under the Central Pension Scheme on exercising option. The petitioner exercised option and his option was rejected by a non-speaking order without citing any reason. On that score, the petitioner moved this petition on the two-fold prayer, number 1 for quashing of that memo, and secondly to be included under the Central Pension Scheme. And after that, initially when the matter was taken up by Justice Arindam Mukherjee, the Airports Authority of India, they were directed to file a report. They filed a report. In the meantime, the subsequent development of the fact is that the application of the petitioner has been now accepted and processed from the ends of the Airport Authority of India. So that is precisely my submission in the exception that I have filed.
So I will direct simply to come to a logical conclusion.
But now, however, the present scenario is that he has not been included under the pension scheme.
Show me from exception.
Yes, sir.
First annexure, page 8. Is it this? Read on.
Inclusion of name of 57 employees under less than 10 years of government pensionary benefit. The competent authority has approved CAD government pensionary benefits with additional 57 CAD employees as per the list enclosed.
Show me your name from the list. Serial number?
Serial number 10, Sri Pothik Bhattacharya.
Very well.
Kindly come to page 11.
So your part of prayer has been satisfied. You are included for consideration. Part of prayer has been satisfied, right? If I direct the appropriate authority to dispose of this and come to a logical conclusion with reason, right, within a stipulated period, nothing remains for the time being in the writ petition, because the moment an executive has taken a decision to consider you, in my view, until the rejection comes, right, your right has not been accrued to challenge it. Your right was there till the time you were not included. Now, since the time you are included, in my view, there is no right for the time being. So I will direct this to come to a conclusion, logical conclusion.
My lord, which condition, my lord? Your lordship, kindly see next page 3, paragraph 3.
Respondent number 1, 2, 3. 1, 2.
Conditional, my lord. Your lordship, kindly see next page, para 3. The conditions are there. Next page, my lord, para 3, my lord. Next page, para 3. The conditions are there, my lord. This is not unconditional, my lord.
Next page.
Yes, my lord. Page 12 of the exception. Page 12 of the exception.
Must be some refund. Must be some.
No, my lord. Yes, some refund, and my lord, earlier whatever he has.
The familiar old DCRV scheme.
Yes, my
of
lord.
the state, that what you have received, you have to give it back, and then with interest, and you will get the new thing with interest.
My lord.
So subject to that condition, in accordance with law, you come to we come to a logical conclusion within 2 months.
My lord, my lord, my lord, my lord.
Yes, now you tell me. Yes.
Let the Union of India comes with a report that they have processed.
I don't mind. In the process, it will be delayed. If you are agreeable, I don't mind. They will come, they will take three extensions. It will automatically 1.5 years.
If my lord directs that within a specified time, the order that the process will come, then we will keep the matter pending.
No. Airport Authority of India is the main respondent.
If I call upon for a report, I will simply call upon for a report. If they come and take extensions, it has to be granted. Choice is yours, madam. A lawyer is good when he or she is a practical lawyer.
My lord knows I shouldn't say like this, but if court's returnable date is there, then
no question of returnable. I will. Madam. From an extension prayer of filing report or affidavit, no content rule is issued. Never. It's a fundamental and elementary to the natural justice. Now, if they come up with 3 extensions, it will automatically take 2 years. Whereas if I direct this to be considered and come to a reasonable conclusion strictly in accordance with law, with reasons, it will be 2 months. Choice is yours. Tell me.
My lord, may I submit some material facts? But because it has not been specifically mentioned by the petitioner. Some material fact is
Mr. Counsel,
My lord,
whether
some material fact,
whether petitioner is eligible or not.
yes, yes. About this, I will submit a
Not required. Your authority will decide and inform it by reason
yes.
within 2 months. Then if she is, the petitioner is aggrieved
She'll challenge again.
with your new proceeding.
In that case, we are not affected.
And if they accept, you succeed.
Get the right.
The airports authority, they have already forwarded my name already
Absolutely.
part of the record.
Absolutely. I will simply say on the basis of this document, page 8, you have shown.
Page 8 and also my lord, page.
Within the stipulated time, they did not submit the option.
That was the initial prayer. Subsequently, the airport authority has itself accepted my prayer and forwarded now. Page 11, that's a part of my exception. This is an admitted position, my lord, from the authorities. My time is 6, page 11.
You tell me which are the documents in the lights of which I will direct. Tell me. You tell me. Which are the documents on the basis of which I will refer the matter.
With the laws.
Junior member is doing very good.
Yes, yes,
Must be encouraged. Yes.
Page 8.
Yes. Page 8 then.
Page 8 of?
Page 8 of my exception.
Yes, page 8 then. You tell me.
Annex, page 11, annex to P12.
P12, 11 of?
Exception.
Very well. Then it is their document, no issues. Then.
Serial number 3 is the name of the petition.
Very well. Who denies? Next.
Yes,
These two. Very well. Ashu. শুধু করলো finally ultimately you became an employee of Airport Authority of India. Yes, yes. As an employee who retired from Airport Authority of India, the petitioner claims certain pensionary benefit under the scheme introduced by the Civil Aviation Department, Union of India. আচ্ছা মাথার উপর ওই নামগুলো বলে দিয়েছি তো সব affidavit of service কোথায় where is that okay first কি বললাম under the name and style of scheme name. Central Pension Scheme.
Under the CCS pension rules 1970.
Framed under CCS pension rules -1972.
Which is applicable for central government employees.
Yes,
yeah.
But you are not going to adapt that. Have you not adapted it?
No, they have been transferred to Airports Authority of India, and
sir, Airport Authority has recommended
retired being the employee of Airports Authority of India.
First sentence I said that. Borun, cheche porun.
As an employee who retired from Airport Authority of India.
Right.
First, কি বললাম? Under the such and such scheme. Bracket for short, the pension scheme. Paragraph. MS such and such, learned counsel appearing for the petitioner, referring to Annexure P and P1 and P2 at pages 8 and 11 to the exception filed in the form of affidavit, submits that the name of the petitioner has already been recommended by the airport authority. Approved, not approved, I don't know. Approval will come from the ultimate authority, madam. That's I said that I referred to those pages.
Finally, it will be sanctioned by the government.
And approved. ঠিক আছে, ঠিক আছে। তো ultimately ওরা দেখবে। যা বলছে লিখে দিই, কিছু ক্ষতি নেই। কি বললাম?
That the name has already been recommended and approved by the
for receiving the. This is not the time. Come after 20 minutes. Pensionary benefit under the said pension scheme. Full stop. The issue is still pending. Before the respondent number, who shall consider? Before the Civil Aviation Department, before the only one. Five shall consider.
My lord, it has to be considered by airport authority, my lord.
Airport Authority of India, my lord.
Airport authority.
2, 3, and 6.
Civil aviation is nothing doing in this matter, my lord. If your lordship sees.
Yes, my lord.
So who shall you tell me which authority?
My lord, the airport authority has to consider. To read.
Airport Authority of India is my lord concerned.
Approving sanction government, the central government will decide. Because the employee is being.
I don't mind. I will direct as per your submission. Very well. But if ultimately the
central government has approved, central government sanctioning.
Very well, very well, very well. কি বললাম? Before the issue is still pending before the.
It is pending before the airport authority, my lord.
Airport Authority of India, my lord. AI.
Civil Aviation Department, as submitted by the learned counsel for the petitioner.
This is not the way.
So who shall take the decision? Respondent number?
Respondent number 2, my lord. Chairman, Airport Authority of India.
Union of India cannot take a decision.
No, my lord. Union of India cannot take decision. At present, my lord, it is, my lord, under the authority of Airport Authority of India, my lord. Because they have transferred to Airport Authority of India from Civil Aviation Department when it is amalgamated in the year 1989.
Approving, central government has approved, that's only. Approving authority.
Central government has only given the
May I be permitted to clear the issue? My lord, this petitioner.
Now wait.
This petitioner initially was employed by this central government under the Civil Aviation Department. And thereafter, in the year 1989, the petitioner has been transferred to National Airports Authority of India. That time,
Thereafter, Airport Authority was formed. And he is an employee of Airport Authority.
He became the employee of Airports Authority of India. Now, my lord, Kindly,
P8.
let me,
P8, page.
my lord, this relevant, why the controversy is coming, I am clearing, my lord.
No controversy, my lord.
Yeah.
P1, page 8.
Yes, controversy is there.
Well, I'm recording his submission, and as per his recommendation, I will make the authority.
Only
P1, page 8.
the material facts are
Who
required
is
to
the
be
competent authority? Lordship will see.
submitted.
P1.
P1, page 8. Exception.
Yes. General Manager HR.
Competent authority has approved
Hmm.
CAD, Government Pension Contribution Additional 57
Okay.
as per the list. This list is forwarding by the General Manager HR.
Hmm.
Scheme is central government scheme. Central
So
government.
tell me the authority's name. You name the authority.
Ministry of Civil Aviation.
Give me the authority. Ministry will not consider.
Director of Civil Aviation, Government of India.
Very well.
Respondent number 5.
Full stop. Learned counsel for the petitioner submits that respondent number 5 is the appropriate authority to consider the issue and come to a logical conclusion with reasons in accordance with law. Par contra, paragraph, par contra, একটা অথরিটির নাম বলতে কেউ পাচ্ছে না, যে শুধু কনসিডার করবে, না আইন লাগবে না ফ্যাক্ট লাগবে।
What I submit below, central government is approving authority.
Sir, you are saying to that 5 is appropriate authority. I'm directing 5. If 5 says I have no jurisdiction, no jurisdiction.
On my word, my lord, see, it's not there, I will try.
That's why the department itself is saying that airport authority.
Airport authority's part is over. Airport is the recommending part.
So let the affidavit come.
Lordship, I'll take it on Monday. Just Monday. I'll confirm it. So that there cannot be any. This order I will be asking for only Monday. Who is the order?
You be লিখে রেখে দিন। Not taking there, which means you are also not sure.
Central, I that's why we got to, so that matter may not be in futile exercise. My lord has passing an order.
So that is why I'm saying before moving the writ petition, you will not know who is the actual authority. You are moving a writ petition and you don't know who is the actual authority.
Central government, appropriate authority, I just take it to.
No. Question is, when you come to move a writ petition, you don't know who is the appropriate authority.
Well, consideration should be done by the.
Your Lordship, kindly see page 12. Who has given the order, my lord? General Manager, HR, Airport Authority of India.
Recommending.
All right. So I am asking the 5 to do that as per your instruction.
So that I should not be matter. Otherwise, it may not be something otherwise. Make it to be mentioned, keep it.
My lord, subject to correction, your lordship may dictate the order keeping that portion blank.
No. কি বললাম, একটা অথরিটির নাম বলতে পারবেন না আপনারা যে কনসিডার করবে, and you are moving the writ petition. কি বললাম? Par contra, learned counsel for the Union of India submits Union of India and the Airport Authority
We are Union of India Airport Authority.
submit that it is the Airport Authority who is the appropriate authority to consider.
My lord, I am not the sanctioning authority of pension, my lord. That is why I wanted to submit some material facts.
Sir, why is the material fact? You tell me X will consider,
lord,
Y will sanction.
They did not state the full thing. Behind of this claim, many problems are there. That I wanted to say. In the approving,
My lord is passing order of
in this,
I am not passing approving. I am saying you consider and you reject it with reason. That which authority will do? Tell me.
that will be better.
Tell me which authority?
Airport Authority will do.
Airport authority is not the sanctioning authority, but processing authority. Processing authority.
Who will process the pension?
Airport Authority has already processed and sent it.
And approved by the.
Now, who is the sanctioning authority?
Sanctioning authority will be the central government, civil aviation department, as well as provident fund organization. Pension
Respondent 6 is not present here.
Respondent number
Respondent 6 is not present here.
If you will be issued by respondent number 6,
Full stop. In view of the above, the parties shall ascertain and inform this court who is the appropriate authority who should come to a logical conclusion in accordance with law on the issue by passing a reasoned order on the next day. The writ petition shall appear under the heading paragraph. Motion service. তাই তো আছে? Motion service on August 7, 2025.
ঠিক আছে। Grateful, my lord.
My lord, I am for the state.
My lord, I am appealing for the petition. Item number 25, 26, and 27 are identical matters. And in all three matters, my lord, there was earlier an direction for filing a report in the form of an affidavit.
So do 25. 25 all parties are here.
Yes, my lord.
Do 25 first.
Item number 25, 26, and 27. Now, my lord, on the earlier occasion, there was a direction for filing a report in the form of an affidavit. But in the first matter, I have not received any report. In the second and third matter, I have received report, but I will pray for time for filing it.
So far, may I tell?
So far, item number 12, I am seeking time for filing.
Just, may I tell one thing? I appear for North Bengal State Transport Corporation. Now, after passing your lordship this order, my learned should say this first instance. These are the three matters. Identical matters already moved and disposed of by your lordship, dismissing the same by my lord, passing a details, my lord, order of your lordship that it's a policy matter. You have not challenged that policy matter, so there is nothing. And my lord, dismiss the same. Now, my lord, the same matter here, the three matters are here. My lord, this is squarely covered by your lordship's order. So, is there any necessity of filing any report any further? He knows that.
Here matter, my lord. There was no direction for filing a report in the form of an affidavit or exception. In the earlier matter, in the first matter, there was only a direction for furnishing instruction. And based on that, my lord, the earlier order was disposed of by your lordship. So, my lord, I am requesting your lordship to kindly take up the matter.
Come tomorrow, next Monday.
My lord.
Next month.
You know the order? You know the order passed?
Yes, my lord.
Yes, in his presence.
Oh, he appeared?
He appeared.
So
he appeared, it was his.
Bring copies of that order and make your submissions on the next.
Oh, 33. Yes, my lord. Instead of Monday, lordship, kindly make it Tuesday.
Then I have to pass an order, then again.
I am requesting your lordship, in the second and third matter, my lord, I am praying for extension of time to file.
I must see the report first. You must argue on the.
My lord, at least 1 week's time maybe.
Judgment
You have to distinguish this judgment, then I will. If you cannot distinguish on law, or on facts,
Yes.
it will cover the.
Yes.
I will try my
Monday,
best.
Monday.
I will try my best.
Come on Monday.
Yes.
আর কিছু দরকার নেই, এটা কভার হয়ে গেছে। 25, 26, 27, same.
Same one.
Twenty-eight, 29, and hearing on behalf of the petition.
28.
28 and 29, being led by Mr. Mani's outstation counsel.
Money?
Mr. Pandey is an outstation counsel. He has appeared before your lordship. Lordship, I'm seeking for a short accommodation. Any day next week, lordship.
Well, next, may I,
Passed over for the day, Monday.
May I, subject to my lord's convenience, in this matter, certain policy decision has been challenged, The central government has appointed Mr. the Lord ASG to represent this case.
He will come.
So some time may be given, next week due to some personal difficulty, I will not be there. Any day, next week, or my lord's convenience. Any day, my lord pleases, This is my instruction, my lord can fix up after fortnight, whatever, subject to my lord. 28, 29 and 32, my lord.
31.
কি একটাই অর্ডার হচ্ছে না আলাদা আলাদা?
Lordship, 28 and 29, I am for the petitioners.
That's different. But order কি একসঙ্গে হয়েছে আগে? একটু কাগজটা দেখি না, না আলাদা আলাদা?
Different orders.
Different orders.
So give your appearances by mentioning serial number.
Lordship.
On the joint prayer for adjournment. On the joint prayer for adjournment of the hearing made on behalf of the parties, the writ petition shall appear under the heading motion service. On August 21, 2025.
And 31 also, 31, 28, 29, 31. 32 নয়।
number?
Please করছো ভাই।
Give the serial numbers.
Mislead হয়ে যাচ্ছে না?
Give the serial numbers.
28, I'm giving the number, my lord.
All the serial numbers.
Yes, my lord, we are giving.
আমার 28, 29 আছে, ওনার 30।
You write in the sleep, proper sleep. Serial number, item number 28 for petitioner this, respondent number this.
Right.
Any.
20, 29.
কবে ফিক্স করলে?
21 অগস্ট। লিখে দিচ্ছেন?
আমারটা লিখে দিন। আমারটা 31 টা লিখে। 20, 29 লিখে দিন। এটা নিন।
Give your appearance in serial number wise.
I'm so grateful.
Next.
বলুন।
I beg to appear on behalf of the Lordship. Petitioner was a constable under the border security.
Who is on the other side?
I am told this.
Passed over. Next.
Number 32, I appeared for the respondent state authority. There was a direction for filing of reports. Accordingly, I have prepared the report, served copy upon the learned advocate for the
Passed
petitioner.
over. Next.
And a copy may be
Passed over. Next.
33, my lord, I am appearing for the petitioner.
Passed over. Next. Passed over. Next. Passed over.
39 to 45, I along with Mr. Kamal Watson.
One by one ডাকতে থাকুন।
39 to 45.
একটা একটা করে ডাকুন।
Fifty-five.
55.
55.
কি বলে দেখি
56, my lord, I go for the respondent.
Yes. Where is your other side? Where is your other side?
I am for the 55.
Passed over next.
62 myself, Your Honor.
62.
62.
Passed over.
At 39 to 45, we take over.
ডাকুন আস্তে আস্তে 133 হয়ে গেছে 3.5 বেজে গেছে
39 to 45, very kindly adjourn.